Good. Good evening, everybody. Are we audible? Are you audible? Please make a message and if I'm audible in the chat box. Thank you. So please go.
Good evening to all of you. I welcome the participants from Vijayawada, Guntur and other places. They have joined us only from today. Welcome to you, sir. Now we start the lecture in the proper perspective. Today's lecture is on drafting, pleading and conveyancing. But as far as professional ethics are concerned, I'll spill it over and then have it in the end, because yesterday what I found was, because there was some time left, I just gave an introduction to professional ethics. Here we will start with conveyancing first before we go to drafting and pleading. Conveyancing is a document or types of documents which includes various documents like sale deed, gift deed, mortgage deed, lease deed, family settlement, partition deed, partnership deed. Then the question is wills. So there are various documents. Or nowadays you've got the MOU also. There is a memorandum of understanding, and then the agreement of sale. Then the question is agreement of reconveyance. There are about nearly many documents are there which are species of conveyancing. Here, first of all, what do you mean by conveyancing? Conveyancing means where a particular property, immovable property more particularly, gets transferred from one person to another. And when we discuss about conveyancing, we must have a thorough knowledge of the Stamp Act as well as the Registration Act. Please remember, this Registration Act also was passed long time back, and that is the reason they say every transfer involving immovable property of the value of 100 and above has to be in writing and has to be duly registered. Then we have the amendment also, which says 17(1)(b) was introduced by the Amending Act of 2001, effective from 1/7/2001, whereby they said any instrument which evidences creation, relinquishment, release, or the definition of rights in respect of immovable property, or any document which reserves an annual rent, has to be in writing and has to be properly registered. Here, of course, the question is, we'll come to it as and when we come, sir. Now, this is the introduction, which for the conveyancing means where a particular property is conveyed or is transferred from one person to another person through a written instrument. That is what is called conveyancing. And most of you are well aware of the Telugu jargon. It is called, a sale deed is called a Vikraya Patramu, Vikraya Dastavezu. That's what it is defined in agency area and even in your Vijayawada and Guntur. Of course, there are different styles of draftsmanship. As far as sale deed is concerned, before we proceed to draft a sale, let us go one by one, sir. First, let us go into agreement of sale. That is Vikraya Oppandamu. That's what they call it in Telugu. That means it is an executory contract where A enters into a contract with B to sell his property for, let us say, 50 lakhs. A is called the vendor and B is called the vendee. A is called the seller and B is called the purchaser. And the amount that is fixed towards the sale consideration is what is called the consideration for execution of the document. And as far the Contracts Act is concerned, we say that the vendor and the vendee both should be majors in order to enter into a transaction. And Section 11, to be more precise, of the Contracts Act says any contract with a minor, person of unsound mind, idiot, or any person who is disqualified by law from entering into a contract, the contract is void, ab initio, and it is nullity. So when you choose a person, you have to choose a correct person who has got the capacity to contract. And most important part of a contract is it must be supported by consideration. And in a sale deed, what happens is, or I'm talking about agreement of sale, where the vendor is the absolute owner of a particular property which he agrees to sell to this purchaser or to the vendee for a particular consideration. Then how the document is drafted. In Andhra area, I have seen విక్రయించిన వారు విక్రయం పొందిన వారు స్థిరాస్తి వివరములు సరిహద్దులు and then స్వాధీన విధము all these things are there, and స్థిరాస్తి schedule also is mentioned. But here in English, what is important is, please remember, I think most of you must be married persons also. When you get married, your ancestors' names are also taken, that you are the grandson or the great grandson of so and so, and you are the son of so and so, and that you belong to a particular gotra, or you belong to a particular nakshatra or a star rather. Then all these things are described. In the same way, preamble of a document, that is a sale deed, agreement of sale or sale deed, whatever it may be, it occupies very important place. Why? Because you try to introduce the document how the seller has got title to the property. First thing you write, please remember, an advocate does not give any importance to the language. We start with the word whereas, ante entanta, that's what we call it in Telugu. That is, whereas the vendor is the absolute owner and possessor of house number so and so, admeasuring so and so, with plinth area of so and so, situated at so and so place, so and so mandal, and so and so district, by virtue of having purchased the same from so and so through a registered sale deed bearing document number so and so, dated so and so. That is how your vendor has become the owner. I am only talking about agreement of sale. Or the vendor has acquired the property, let us put it another way. He has acquired the property through a gift settlement deed executed by his father or mother in his favor through document number so and so, dated so and so. And if he has acquired the property through a will, then he says, having inherited the property or succeeded to that property by virtue of a registered will executed by so and so in his favor by the document number so and so, dated so and so. But please remember, the one trick for you to make money when you draft a document is, you also trace the title or the vendor of the vendor. That is, vendor you have traced, then vendor's vendor, how he has got the property, how he had purchased the property, how he has acquired the property, what is the document through which he has acquired the property, and what is the date on which he has acquired the property. Please bear one thing in mind, that preamble plays a very important part in introducing a document. So preamble is introduction that is given to the document which you are going to draft. So without a preamble, without an introduction to the document, your document is incoherent and imperfect. Then next paragraph, what you write is, whereas the vendor has agreed to sell the schedule mentioned property to the vendee for a total sale consideration of rupees so and so. The next paragraph, whereas the vendee has accepted the offer of the vendor and agreed. Please remember the word agreed, because it's an executory contract. We are dealing with agreement of sale. Whereas the vendee has agreed to purchase the schedule mentioned property belonging to the vendor for a total sale consideration of rupees so and so, and in terms of the agreement, he has paid a sum of rupees 10 lakhs towards advance and earnest money, the receipt of which is admitted and acknowledged by the vendor, and the balance of the sale consideration is agreed to be paid, and the transaction completed within a period of 6 months. So there is consideration mentioned, passing of consideration is mentioned, receipt of consideration is mentioned, and the document is not an incoherent document, and the document through which your vendor and acquired the property is also mentioned. Now, please remember one thing, don't use the word past tense. You only say agrees to purchase. Agrees to purchase means it is not yet over. He agrees to purchase at a later date. And towards the said purchase, he has paid advance and earnest money. That also has to be recorded, and there must be an admission and acknowledgement of the receipt of the sale consideration by the vendor. Then we come to now this agreement of sale witnesseth as follows. One, that the vendor, please remember again I'm emphasizing the word, the vendor hereby agrees to sell, please follow the wording please. The vendor agrees to sell, convey, transfer all its right, title, and interest in respect of the schedule mentioned property unto the vendee, together with all easements and appurtenances attached thereto. I tell you what you mean by easements. Please remember, sometimes you have rights over your property, no one is going to dispute it. But you acquire certain rights by long usage of time over a neighbor's property. That is what is called easementary right. Right of passage, right of air, right of sanitation, right of ventilation, right of what is called letting out sullage water or drainage water through this area. All these things are there. They are called easements. Then appurtenances. What do you mean by appurtenances? Appurtenances means doors, windows, then fittings, electrical fittings, wiring, motor, borewell, then sump, all these things which are there, they are called appurtenances. You don't mention in the document 10 doors, 15 windows, then one motor of so and so, so and so, so much of pipeline, then again wiring, all these things you don't mention. You only say appurtenances. Appurtenances means whatever is attached to the property for enjoyment, it is what is called appurtenances. Then second one is, whereas the vendee has accepted the offer of the vendor and agreed, please remember again, please underline the word agreed, and agreed to purchase the schedule mentioned property belonging to the vendor for a total sale consideration of rupees so. Then the third one is the vendor, the vendee has this day paid the vendor a sum of rupees dash towards advance and earnest money towards the contract, towards the agreement of sale. Then fourth one is the vendor hereby admits and acknowledges receipt of rupees so and so towards advance and earnest money. Then the next clause is the vendee hereby agrees to pay the balance of the sale consideration within 6 months from the date of this agreement. The next one is the vendor hereby admits and acknowledges receipt of rupees so and so towards advance and earnest money and agrees to receive the balance of the sale consideration within 6 months from this date. Then the next clause, the vendor hereby declares that that there are no encumbrances, rival claims, charges, court decrees as far as the schedule mentioned property is concerned, and agrees to indemnify and keep indemnified the vendee against all future losses in case of any defective title. That is an indemnity given regarding the title of the vendor. Next one is the vendor further declares that he is the sole and absolute owner and possessor of the schedule mentioned property, and no person apart from him, including his legal heirs, have got any manner of right, title, or interest over the schedule mentioned property. Then next one is the vendor further declares that the schedule mentioned property is not an assigned land and hit by Act 9 of 1977. Then then the next paragraph it says the market value of the property as far as the records of the sub-register government value is concerned is so and so, and this particular document is engrossed on a stamp paper of so and so. Then the next paragraph you says in witness whereof the vendor has set his hand and affixed his signature oblique thumb impression on this instrument voluntarily without any compulsion or force And if the vendor is not acquainted with English, you say after the contents were read over and explained to vendor in Telugu or Urdu, which he understands. Then the vendor affixes his signature, and nowadays it's also common that the vendee also affixes his signature. Then you have the witnesses on this side, witness 1, witness 2. Then you have the description of the schedule of property. Just like you describe yourself as Srimati so and so, wife of so and so, age so and so, occupation so and so, resident of so and so. The same way, a property also has got a description. It has got a particular location. You say all that piece and parcel of house number so and so, in plot number so and so, at measuring so and so square yards, with built up area of so and so square feet, situated at so and so mandal, so and so village, so and so district, bounded on the north by so and so, south by so and so, east by so and so, and west by so and beneath it, the vendor signs and the vendee signs, and the witnesses sign on the other side as having witnessed it. So, this is a sum and substance of an agreement of sale. So, what is the significance of this? There is a particular, and please remember, you cannot enter into a contract with yourself. You cannot enter into a contract with another party. That is, in other words, you cannot say that you will marry yourself. You marry a female as a partner. In the same way, as far as an agreement of sale is concerned, there must be two or more parties. That's the first essential ingredient. Second one is there must be a tangible, immobile property. Third one is the mode of acquisition of that property by your seller has to be clearly mentioned in the preamble. And the mode of acquisition of the property by your vendor's vendor also has to be mentioned clearly through which document he has acquired it and by what mode he has acquired it. Then we come to the whereas the vendor. Then we come to how the vendor. Please remember what are the essentials of a contract, sir? Offer, acceptance, capacity, consideration, and legality of object, isn't it? Six essential ingredients as laid down in section 6 of the Contracts Act. So first there must be an offer. Next one is there must be an acceptance. Third one is there must be consideration. Fourth one is there must be consent. Fifth one is legality of object. So these essential ingredients will have to be present in every contract. Even an agreement of sale is a contract inter se, the vendor and the vendee. So why do you mention the preamble, sir? Because even if you have money, to avoid income tax, what people do is they pay the money in a phased manner. So first is they enter into an agreement and spell out the conditions on which the agreement is made. Nowadays, please remember this agreement has also permeated into the matrimonial sphere also, where అందుకే మీరు తెలుగులో అంటారు నిశ్చయదార్థం అంటారు పూలు పండ్లు అంటారు చూడండి వేర్ యు అగ్రీ టు గెట్ మ్యారీడ్ ఆన్ ఎ పర్టికులర్ డేట్ లగ్న పత్రిక చదువుతారు ఆ రోజు దట్ మీన్స్ ఒప్పందం అయింది అనమాట a particular person and a particular girl are going to be locked in a wedlock on a particular day at a particular time. Their nakshatram or their star will be mentioned, their gotra will be mentioned, and the star and the gotra or the boy also will be mentioned, and it is also signed by the bride as well as would be bride and would be bridegroom and the parents of the bride and parents of the bridegroom. Please remember now this has almost permeated itself into our Hindu culture also. But as far as Muslims are concerned, the Qazi records everything when the marriage is about to be fixed or the nikah is about to be fixed. You say Muslim marriage is supposed to be a contract and a Hindu marriage is sacrosanct. But please remember, it's the other way around now because of the intervention of the IT. IT has spoiled everything. There is absolutely no bondage between husband and wife. There is no love between husband and wife is more educated and earning more than what the husband earns, and a sort of inferiority complex creeps into the husband, or the wife also gets a superiority. That's all different thing. Why I'm trying to tell you is that almost these agreements have permeated itself into every sphere of activity. First and foremost is there must be an offer. Next one is there must be acceptance. Then there must be capacity. Why do you say capacity, sir? Capacity is because the vendor, that is Atta Somu Alludu Danam Jeyadu, that the vendor should have a clear title because of name out at quadnon habit. No man can pass a better title than what he himself has. So your vendor who is going to transfer the property to you must have title. How does he acquire title, sir? He acquires either by sale, he acquires by what is called gift, or he acquires by auction sale, or he acquires by a will, or he acquires by some other mode, which is a recognized mode of acquisition of property. And one of the tricks which I pass on to you is when you draft a document, your client is guided by the volume of papers which you use for drafting it. That is the reason I quote the late President of the United States, Sir Abraham Lincoln, who says, an advocate is fond of air splitting and pedantry. That means an advocate does not go to the matter straight. He goes from a roundabout way and come to the real matter. And if he doesn't do it, he's not an advocate at all. Then we describe the property. Then after that, we say there is an offer. Sale consideration is fixed. Then next one is consent also is given. Acceptance is also there. Advance is also paid. And the remaining money is agreed to be paid at a future date. Then we come to the operative portion of the document. The vendor hereby, please remember again, I'm repeating the word, emphasize on the word agree. The vendor hereby agrees to sell, convey, transfer all his right, title, and interest in respect of the schedule mentioned property unto the vendee, together with all easements and appurtenances attached thereto for a total sale consideration of so and so. Again, I gave you the importance of appurtenances and easements. Easements is a right which you don't have over your property, a right by long usage which you enjoy over a neighbor's property, right of ingress, right of egress, right of drainage, right of letting out rainwater, right of what is called light, sanitation, air, so on and so forth. They are all easementary rights. And when I come to transfer of property act, I'll tell you they are called servient heritage. Along with the proprietary rights, you also get those rights also. So the question is, that's why I use the word appurtenances and easements attached thereto. In the document, we don't mention 20 doors, 20 windows, then 20 pipelines, then 20 wiring, then electric motor, then pipelines supporting the electric motor, the pipes which are used in the electric motor, then the trees which are there. Also, we don't mention. They are all called appurtenances attached to the scheduled property. Then we say there is an offer by the vendor to sell the property, and the vendor accepts the offer and agrees to purchase the schedule mentioned property for a total sale consideration so and so. Then the third one is, you say the vendor has this day paid a sum of rupees so and so towards advance and earnest money, the receipt of which is admitted and acknowledged by the vendor. Then you say the vendor agrees to pay the balance of the sale consideration within 6 months from the date of agreement to the vendor. Then next one is the vendor hereby agrees to receive the balance of the sale consideration within 6 months from this date. Then the next clause is the vendor hereby declares that the schedule mentioned property is free from all encumbrances, rival claims, charges, or mortgages, and that he has got a clear, absolute, marketable, and unencumbered title, and agrees to indemnify and keep indemnified the vendor against any future defective title. Then next one is the vendor also says that he is the sole and absolute owner and possessor of the schedule mentioned property, and no other person, including his legal heirs, have got any rights over the property. The next one is the vendor hereby agrees and undertakes to execute and register the sale deed on the payment of the balance of the sale consideration within a period of 6 months, and in case of default, the vendor is entitled to get the same enforced through specific performance in a court. And whatever expenses are incurred towards the court litigation, a sum of rupees 5 lakhs is agreed to be paid by way of liquidated damages. Then next one is the vendor hereby agrees to pay the balance of the sale consideration within 6 months from the date of this agreement, and further agrees that in the event of default in payment of the balance of the sale consideration, the advance shall stand forfeit. They write the word forfeited, but it is not the correct word, because under the specific relief act, the word forfeiture, court will not enforce it. The amount of advance which has been paid shall be refunded by the vendor without interest. Then again, The vendor hereby declares that he agrees to deliver vacant possession of the schedule mentioned property to the vendee immediately on execution and registration of the sale deeds. The next clause, the vendor hereby further agrees to hand over all the legal documents pertaining to the schedule mentioned property to the vendee immediately on execution and registration of the sale deed. Then after that, you mentioned, sir, that in witness whereof the vendor hereby further agrees to cooperate with the vendee in getting the mutation done in the municipal records. Then last one is in witness whereof the vendor and the vendee have set their hands on this instrument voluntarily without any compulsion or force after the contents were read over and explain in English, oblique Telugu, oblique Urdu, oblique Malayalam, oblique Kannada, so on and so forth, which they understand. Then the witness signs, and vendor signs. The vendee also signs, and the witnesses are there on the other side. Witnesses 1, 2. Then what is important in every transaction of immobile property is the schedule of the property has to be clearly mentioned. All that piece and parcel of house number so and so, in plot number so and so, admeasuring so and so, with plinth area of so and so, comprising of ground and first floor, situated at so and so mandal, so and so taluk, so and so district, bounded on the north by so and so, bounded on the south by so and so, bounded on the east by so and so, bounded on the west by so and so, and then beneath it, the vendor and the vendee both sign on the document. This is how a Vikraya Patram or a say agreement of Vikraya Oppandam, I'm not saying Vikraya Patram, Vikraya Oppandam. Vikraya Oppandam means agreement. Vikraya means sale agreement. That's how we have to take it in Telugu. So, Sari Addulu, that is the boundaries have to be clearly mentioned, sir. Just like you describe yourself as a son of so and so, age so and so, occupation so and so, resident of so and so, even a property has got a proper description, property has got a proper location, property has got certain boundaries, and they have to be clearly and succinctly mentioned. This is how an executory contract is made, and it is called an agreement of sale. Then, sir, what is the distinction between agreement of sale and a Vikraya Patram? That is what is called a sale deed. Here, as far as the Vikraya Oppandam is concerned, or an agreement of sale is concerned, it is an executory contract. So, why some of the obligations are performed and the rest of the obligations have to be performed at a later date, right? Suppose one more clause also you can add, sir. Sometimes you want to purchase agricultural land, sir. You require clearances, you require permits, you require the government permission in order to sell the property. Or let us say you do not know where your land is. You know, have no doubt have the layout, but it has to be properly localized. Previously, what they used to do is they used to address a letter to the revenue department, survey and settlements, and a revenue inspector comes from there with the old system of chains. That is what is called Doana, Charana, and all. I think the gentleman here, Mr. Krishnamurti, must be knowing it. That is, they used to call it as two annas or charana or whatever. But now those days are gone. Now with the Google map, they take the satellite picture and come to the correct location, and the calculation is made correctly. So the question is, suppose, or let us say some clearances have to be taken. Then they say, I'll get the land surveyed, I'll get the land localized, I'll get the boundary stones fixed, I will take the help of the survey and settlements and get all these things done. Then they say till such thing is done, the question is there is no question of adhering to that 6 months period, please. Sometimes it may take 6 months, sometimes it may take 1 year, or sometimes it may take 1.5 years. The time for performance would come only after all the things are done. Then it is said the document is ripe for being executed and registered. But please remember, under the present law, which is prevalent, Section 17(1)(b) of the Registration Act, all agreements of sale also has to be properly stamped and properly registered. Without that, the document is unenforceable under the law. In this regard, sir, nowadays a lot of hybrid documents are also coming. I think perhaps you as advocates know. Unfortunately, we are not able to keep track of it. The one thing is what is called AGPA, which is very, very, very common. agreement of sale come GPA. That is double role. Here, the Wendy becomes the title holder, and Wendy also becomes the power of attorney, or what is called Mukhtiar, or what is called power of attorney of the vendor. Even an agreement of sale come GPA requires writing, requires registration, requires proper stamp duty to be paid, and the registration charges also to be made. Why I'm trying to cite that is there is one leading case of the Supreme Court, that is the in 2004 or 2005, popularly called the Suraj Lamps case. That is a case of Suraj Lamps versus the Metro Development Authority, New Delhi. In that, the point that arose was whether an AGPA can be enforced specifically under the specific relief act was a question. The Supreme Court clearly laid down the guidelines by saying that an AGPA ipso facto by itself is not enforceable, and you cannot get a decree for specific performance unless the entire consideration is paid, number one, or the entire and not or and the entire stamp duty paid, entire sale consideration being paid, then only the AGPA can be enforced in a court of law. So, gone. That is the reason why Section 49 of the Stamp Act was what is called was amended, whereby they say the entire stamp duty has to be paid and entire consideration has to be paid, and then alone and the document then alone will be enforced in a court of law. If not, Suraj Lam's case says that if these two things are not present, court cannot enforce specific performance whenever a suit is filed under the SRA or the Specific Relief Act. Of course, I encountered this problem in one of the cases at Siddipet, where my colleague was appearing was in a fix because the judge had, I think the judge's name is Srimati Pratima Reddy, who was the judge, then judge of the additional district judge in Siddipet. Now she is the principal district judge of Karimnagar. She laid a query saying, sir, under the Suraj Lam's case, all AGPAs will have to be registered, and all AGPAs, the entire sale consideration has to be paid, the entire stamp duty has to be paid. Then I was asked to clarify that particular position and told the judge, sir, you cannot have the example of Suraj Lam's case in almost every case because there is some distinction which also has to be made. Reading of the document clearly shows the entire consideration was paid and the entire duty was paid. It was also endorsed by the sub-registrar that the entire stamp duty was paid and the consideration was paid, and execution of the sale deed was only a formality. Then in that case, the Suraj Lam's case does not apply, please. That's how I was able to distinguish that particular problem. And the judge afterwards also I was told, I don't know because I never appeared before her. After that, she tries to make a distinction as far as the Suraj Lam's case is concerned. If not, she had a formula like what is called Mix Action 500. For everything, she used to say that Suraj Lam's case, and she used to dismiss the suits. Please remember, don't be disappointed. Try to distinguish it. Try to find out whether the entire stamp duty has been paid, entire sale consideration has been paid, and all formalities have been followed. Please remember, then in that case, the Suraj Lam's case does not apply. Then, sir, why is it called a hybrid document, sir? Nowadays, we are having hybrid vehicles. I think perhaps you know both gas as well as the petrol. Then you are having now electric cars are also, they are all called hybrid cars. Without the normal energy, with alternate energy, they can run the car. Now, what they do is, why GPA is taken by the purchaser is that he can execute the document unto himself, because the word that is used is the word that is which term shall include. Wendy's description will be shown as which term shall include all his heirs, assigns, nominees, and legal representatives. He is also one of the nominees. So instead of executing a sale deed in favor of a third person, he can execute the sale deed in his own favor by virtue of being the nominee of the seller. So that is the advantage of AGPA, sir. But one thing is this, the significance of AGPA is most of the Marwadis or the businessmen enter into such transactions. The reason being, they don't want to show the consideration. By the time the income tax people wake up, the sale consideration, the transfer is already over. because you have got the GPA through which you execute the document for and on behalf of the principal in favor of a third party and get away from that. Then another question arises, sir. What is the stamp duty I have to pay? Should I pay the stamp duty that is prevalent in the market or the stamp duty which is mentioned in the books of the registrar? Please remember, government is not a fool now. Government also has woken up. Government has fixed especially during the 10 years of previous regime, they hiked up all the rates of properties because one of the ways of recovering revenue is only from property. And another is, of course, liquor, IMFL. Here, as far as property values are concerned, the registrar keeps a book with him, and according to that book, per square yard or per acre, the area, the rate is fixed. And naturally, sir, don't be guided by the consideration that is shown in the document. The document will only show the consideration that is in the books of the registrar. But as far as the consideration is concerned, there's some other consideration also. Most of you know. Suppose a property, the book value is 30 lakhs, but the money which has been passed on is not 30 lakhs, but it's 50 lakhs. That's how the black money is generated, sir. So that is the reason we as advocates advise the party, be it the seller or be it the purchaser, to have two types of agreements. One is the actual consideration, and the other is the consideration as per the book value shown by the government. And when the sale deed is to be executed, what we do is we destroy both the agreements. Why? Because both of us are thieves, will get caught as far as when we file these documents. Then the question arises, sir, suppose the matter goes to court, the vendor does not execute the sale deed. Then in that case, whatever is the official value, whatever is the book value, whatever is the value shown by the government in its books, that is the value for the purpose of executing and registering the sale deed. And please remember, it is advisable for you whenever you make a payment above 10,000 to give it by, because the Reserve Bank regulations say that it has to be given by demand draft only. Now, of course, it has been enhanced after Nirmala Sitharaman took over as a finance minister. Now, any payment above 50,000 has to be by check or has to be by demand draft. It cannot be paid by cash. So these are the incidents of an agreement of sale. That is Vikriya Oppandamu. That is the word. Please remember, not Vikriya Patram. Vikriya Patram is an executed contract. Vikriya Oppandamu. Vikriya Oppandamu means that is an agreement to sell. And the significance of an agreement of sale is the word agree is used. But as far as the sale deed is concerned, we use the word already is a past. That is agreed to purchase, agreed to offer, agreed to pay, paying so and so. That means it is in the present. As far as agreement of sale is concerned, something is done at one time, some things have to be done at a later date. But as far as a sale deed or a Vikriya Patram is concerned, everything is done simultaneously, immediately across the table. It is called the Vikriya Patramu or it's called the sale deed. So that is a distinction between an agreement of sale and a sale deed. And please remember, all suits for enforcement of a contract by way of specific performance from section 10 to 24 of the Specific Relief Act arises only relating to agreements of sale. Please remember, agreements of sale means executory contract. But as far as executed contract is concerned, when the contract has already been concluded, when the sale deed has already been executed, when the sale deed has already been registered, then no specific performance suit would apply as far as executed contracts are concerned. And some of the Muslim candidates who are present here, I think perhaps you know Urdu very, very easily. There is a word used called Farokt Nama. Farokt Nama means it's a sale deed. It's a Vikriya Patram for all practical purposes. The obligations on both the sides are completed. There's nothing to be completed. That is the word Farokt Nama. Farokt Nama means it's an executed contract. That's a Urdu word, sir, which is used. I think perhaps having come from Arabia or Persia, that word is still used by most of the Muslims when they draft the document in Urdu. Then there is a word used also in Telugu when they draft, that is Putra Pautra Paramparikanga. That is not only for you, for your son, for your grandson or your great grandson. That is for generations to come. That is the Telugu word which is used. That putra pautra paramparikanగా నీ స్వాధీనం చేయుచున్నాను. That means that is for generations of your family. I am transferring this property to you. Absolutely. Those are the wordings used in Telugu and in English also. We say, when you say absolutely, that means the vendor has shed all his rights over the property, and the rights which he had, he parts with possession, hands it over to the vendee, and in return, he gets the sale consideration which is paid by the vendee for acquiring that property. So, all the essential ingredients of contract, like what is called offer, acceptance, capacity, consent, consideration, and legality of object, have to be present as provided in section 6 of the Contracts Act. Alongside, you must also get the document properly stamped and properly registered as per the amendment of the Registration Act, where 17(1)(b) has been introduced, whereby all transactions relating to immovable property which creates rights will have to be duly registered and in proper stamp. So this is as far as the Vikraya Patramu, or what is called Vikraya Oppandamu, or agreement of sale or sale deed is concerned. That is the first document which we discuss. So whenever you draft a document, you try to know the definition of the word that is used. What is the word that is used? Sale. Sale. How a sale is defined under section 54 of the Transfer of Property Act, it says where there's a voluntary transfer of property from one person called the vendor to another person called the vendee for a consideration called the price, it is called a sale. Where there is voluntary transfer of property from one person called the vendor to another person called the vendee for a consideration called the price, it is called a sale. So, if you are able to understand the meaning of the term, your documentation becomes very, very easy. And that is the reason, sir, when you draft a document, follow the American system of drafting, where you have short sentences and then more number of pages, and the fees which is going to be paid by your client is going to be much more than what you write in one page. But if you see what a document writer writes, he follows what is called the basic principle of saying, he has come, he has conquered, and he has gone. Oche, kotte, teche. But that is not in one page they'll write. Even you as an advocate can write it in one page. Please remember, if you write it in one page, your client also will pay you one page fees. If you write it in 5 or 6 pages, and preferably with double line or triple line in the document, then the question is your fees also becomes voluminous. The question is, you are going to draft the same thing, but basic essential ingredients you will have to be very, very careful. So what plays an important part, sir? Identity of the vendor, identity of the vendee, the mode through which the vendor has become the owner, the mode through which your vendor's vendor has become the owner, and the amount that has been agreed towards sale consideration, the amount which is paid towards the advance and earnest money, how the balance is going to be paid, within what time, then what are the obligations which are cast on the seller to get the property free, the permissions, permits, so on and so forth. Then the question is, there is a clause regarding the indemnity clause, where the vendor says that he is the sole and absolute owner and there are no encumbrances, rival claims, mortgages, etc., etc., and agrees to indemnify the vendee in case of any defective title. And then there's an important clause is the how the possession is delivered or agreed to be delivered at a future date. And then the linked documents being handed over in proof of execution and registration of the sale deed, and then the signature or verification of the vendor and the vendee that the document has been properly drafted. And then after that, you got the schedule of property and you give the description of the property. And then you also have a sketch enclosed along with the previously what we used to do is we used to get the sketch prepared in a blueprint. Now blueprint is not being accepted because we are in an era of information technology. What they do is they try to scan the plan and then introduce it into the computer and then take out an electronic image from that, and that part forms part and parcel of the document. But if you see the old Dastavej, those days, I'm talking about during Nizam's time in Hyderabad, all the Dastavej or the documents were only in one page. Normally it was in Urdu. And please remember, I think the computer in this country came very, very late. I think it came somewhere around, if my knowledge goes better, it must be 1980 or 1975. But before that, it was manually written or it used to be manually typed and it was written with handwriting. Please remember, it's very, very difficult for us to follow and decipher what the handwriting means. That is the reason once we introduce that into the court, we have to get it translated also and then file it because the court also cannot, you can neither you can read it nor the court can read it. So you have to file a clean copy. So this is as far as the Vikraya Oppandamu or Vikraya Patram, that is agreement of sale or sale deed. But the difference between both of them is agreement of sale is supposed to be an executory contract and sale is supposed to be an executed contract. And if you want to have the legal remedies, a suit will lie for specific performance only when it is an executory contract. That means some of the obligations are performed and the rest of the obligations are going to be performed at a later date. Then only a suit for specific performance would lie. But a suit for specific performance would not lie regarding executed contracts. So this is agreement of sale and sale deed. Then we go to the second type of and please remember, so you can ask me one question, sir. What is the stamp duty which you pay? I think if I'm correct, the stamp duty varies from time to time. It comes to almost 11%, that is 6%, and 5% towards the transfer tax, and 1% towards the registration fees. And alongside the sale deed which you're presenting for registration, you have to submit the copy of the linked document, copy of the Aadhaar card, then copy of the what is called uh, tax receipt. All these things you have to enclose. And then there's one thing called Annexure 1A, Annexure 1B, and all. You give the description of the property, and then you also submit it along with the plan. And then all the sale deeds which you file before the registrar, you are supposed to give an extra copy also. So that please remember, the registrar office also has become very, very lazy now. What they do is previously they used to record it in writing. Now what they do is the extra copy what you give, they paste it to the register and keep it. They say neat and clean, clean and green, whatever it is. So whenever you want to, it becomes, once it's registered, it becomes a public document. Any person, not only you, the executant, but also a third party can get a certified copy of that document, provided you show the registration number, the date of registration. Any person can get it, and if you're a third party, you must also give an application why you require it. Again, in this regard, I would like to alert you. And suppose some of you are appearing for the banks. The banks have also introduced a new rule by saying search report. Hyderabad is very, very notorious for selling properties. One property, one plot is sold to 10 people. Who is the actual owner? Who is the actual person to whom it has been sold? To whom who is liable? And all these things are very, very difficult to follow. And especially when these documents are deposited in the bank by way of collateral security to secure a money loan, the bank finds it very, very difficult to trace out who the actual owner is. It is something like having multiple marriages. You can't manage with one, but you have to manage with 10 people, let us say. How difficult it is for the bank to recover its money. So what they do, please remember your Takatu Patram, as they call it, your encumbrance certificate will only show the documents in the record which is already registered. But the banks normally resort to what is called equitable mortgage or mortgage by deposit of title deeds. And once it's a deposit of title deeds, what they do is the bank only keeps it and it's not entered in the Takatu Patram or the encumbrance certificate. And sale deed also takes place because certified copy or so and so, the sale deed takes place. Then the bank's interests are affected. So now what the banks are doing is they have opened their eyes and they have asked the advocate concerned, who is a standing counsel, to take a certified copy from the registrar's office, search the registrar's records, the register, find out whether there is such registration in respect of that property. If the registration is there, does it correspond to the original document? or whether the identity of the property is the same as shown in the register, and whether the sale deed and the register tally, and there are no subsequent transactions in respect of that, and you have to file what is called a search report saying that you have searched the records of the sub-registrar and found these things. So the bank wants to be on the careful side, and they are introducing these particular precautions. And then now the banks are also insisting, even if it's a case of a mortgage but deposit of title deeds, though it does not require registration, they are getting that registered. After all, what registration fee, what stamp duty is payable is only 0.5% or 1% is levied, and 0.5% is levied towards the registration charges. So one advantage of that for the bank is it will be recorded in the Takatu Patram or the encumbrance certificate regarding the title in respect to the property. So the bank's interests are saved. So that is one lacuna, sir, because mortgage by deposit of title deeds doesn't require registration. But once it is reduced to writing and the particulars of the loan transaction is mentioned, the earliest case decided on that particular aspect is the Das Bank's case of 1947, where they say if equitable mortgage is reduced to writing, mentioning the terms of payment, mentioning the interest, the amount of loan, it is a conventional type of mortgage. It requires a stamping and it requires registration. Nowadays, that is the reason why banks are resorting to cheaper methods. They say by memorandum, they say the documents have been deposited, so on and so forth. But also they get the memorandum deposit of title deeds also registered so that the bank's interests are saved. So this is as far as the Vikraya Patram or the Vikraya Oppandam, or what is called an agreement of sale and a sale deed. The only difference between both of them is the word agree is used, agrees to sell. But in sale deed, as sold, conveyed, transferred, all is right title interest. That is already a fait accompli. That is a sale deed. But that fait accompli will be only later. Agreement of sale will only say promise to convey. That is agree to convey. That means it's in future after a particular duration of time. But as far as the sale deed is concerned, it is immediate. That means it is immediately executed, immediately registered, and then the title passes, or the ownership passes, rather, I put it that way. So are you able to understand the distinction between agreement of sale and sale deed? Or not akrama, Vikraya Oppandam and Vikraya Patram in Telugu. That is as far as the sale deed is concerned. I would like to go a bit slow in this conveyancing, and also conveyancing, drafting and pleading, and the professional ethics. We'll discuss it because yesterday I just gave a passing reference to it, but I have to refer to professional ethics from the point of advocacy, from the point of what is called misconduct, and the significance of professional ethics on the part of the judge and on the part of the advocates, the etiquette which an advocate has to follow, the etiquette which the judge has to follow, the dress code which the advocate has to follow, and the behavior in the court called etiquette. Also, I will discuss it in the end after I finish conveyancing and after I finish drafting and pleading. I think yesterday one question was asked by Srimati Anuradha Bakaraju. The question was, suppose the drawee loses the check which is given to him by the drawer, what are the steps he has to take? And let us say the person who finds the check encashes the check. Then in that particular scenario, what should happen is, suppose the drawee immediately has an impression that he has lost the check. But preferably when he takes a check from the drawer, it is better he makes out a Xerox of the check and keep it with him, and also find out on what bank or which branch the check has been given, and then immediately inform the drawer and ask him to countermand the check and cancel the check and say the check is lost. Please don't make any payment as far as the check is concerned. Stop payment, as you call it. Or the drawee himself, based on the Xerox copy, can go to the bank and say, sir, this check has been stolen or this check has been misused by someone. Please try to stop payment. Please remember how the bank also pays, sir. Suppose I give you a check, bank takes your signatures in the reverse and also takes your phone number. Through the phone, you can contact that person who has found your check and encashed it. And nowadays, you've got the CCTV also. CCTV images are there through which you can find the person who has found the check. I think that was a question asked by Srimati Anuradha Bakaraju. But the question is, I said, it's a disaster losing a check. But the question is, there's definitely a remedy. But you must act very, very fast. You must stop the payment, whichever bank it has been given, when it has gone to your bank for encashment. And before it reaches the clearance house, you must take that action. If not, once the payment is made, the bank is not liable in any way. I think that finishes the sale deed and the Vikraya Opandam and Vikraya Patram. I'll go through every document very, very carefully, sir, very, very slowly, because it has got an importance in our day-to-day drafting is concerned, day-to-day life as an advocate is concerned, and no one can attain mastery unless and until by experience. Your books will not take you anywhere. No doubt I know what are the books available. One is a book on conveyancing by Moga, one is a book by Bindra as far as conveyancing is concerned, and another easier book for the students are D'Souza's book, which contains simple language and model documents. So, but it comes mostly by experience. But you must know the distinction between agreement and what is called sale deed, agreement of sale and sale deed. The agreement emphasis is given on the word agree, but as far as the word sale deed is concerned, agreed. So one is in present, one is what is called at a future date. Another is it sale deed is it is on the one and the same day when the execution and registration takes place. So this is what is called the Vikraya Patramu and Vikraya Opandam, or agreement of sale and sale deed. Yes. Now the interaction period starts, please.
Vasantara Garu, you can unmute yourself.
Good evening, sir.
Good evening, Babu.
Sir, please elaborate the Suraj Lam case and
Sir, as far as Suraj Lam's case is concerned, it was a case between Suraj Lams and Metro Development Authority of New Delhi. The question that arose in that particular case was, when a suit is filed for agreement enforcing a contract, or more particularly an AGPA, agreement of sale come general power of attorney. The question arose whether such an AGPA can be specifically enforced under the provisions of the Specific Relief Act contained in section 10 to 24 of the SRA. Then the Supreme Court in this particular case laid down guidelines as far as AGPA is concerned, whereby they said because section 49 of the Stamp Act was amended, whereby they said that any agreement of sale come GPA, the entire sale consideration has to be paid, and the what is called entire sale consideration has to be paid, and the proper stamp duty also should be paid. Then alone an AGPA is enforceable. In that particular Suraj Lam's case, what happened was, though it was drafted in the form of an AGPA and a suit was brought for specific performance, the court said since the entire consideration was not paid and it is not on a proper stamped paper, they say specific performance cannot be ordered. So the ratio of the case of Suraj Lam's case was that if you want an AGPA to be enforced by specific performance, the entire stamp duty has to be paid and the entire consideration has to be paid. If not, the AGPA has to be consigned to the waste paper basket. But this can be distinguished by showing, if you carefully go through the document, what is the sale consideration agreed, what is the sale consideration paid, and nowadays after the Telgi scan, perhaps you know, whenever a document is registered, the registrar endorses on the reverse saying the entire stamp duty of so-and-so paid. So much amount paid towards the stamp duty, so much amount paid towards the transfer duty, so much amount paid towards the registration duty, and the total amount is given. And there is an acknowledgement also, there is a admission by the sub-registrar that the entire things have been paid. Then the question is, what is called the Suraj Lam's case has no application. If the sale consideration has been paid, the registration charges have been paid, the transfer duty has been paid. Yes, are you able to follow, please? If entire thing is paid, then the question is specific performance can definitely be ordered. But if it is not paid, that document is of no value. A AGPA cannot be enforced through a court of law, and the specific performance cannot be ordered. That is
Okay,
the
thank you, sir.
crux of that Suraj Lam's case. But unfortunately, what is happening is most of the judges are using it as gospel now, like Bible. They are saying Suraj Lam's case. Please remember, if you carefully go through the document, you can definitely distinguish the Suraj Lam's case. If your entire consideration has been paid, stamp duty has been paid, registration charges has been paid, transfer duty has been paid, there is absolutely no age for getting a specific performance decrease. Yes, next.
Sir, sir.
Next.
Please, sir, please. I cannot follow it.
Who is
Last.
Sir, the question is, if the entire stamp duty is paid, entire transfer duty is paid, entire registration charges are paid, and it is endorsed by the sub-registrar on the reverse of the document, such a AGPA can always be enforced, sir. That is an exception to the Suraj Lam's case. Are you able to follow, sir?
Yeah, yes, sir. Thank you.
Welcome.
Thank you, sir.
Right.
Yeah, very much enlightened.
Thank you, sir.
Any more questions? Please go ahead.
Sir, I have one question.
Sir,
So one by one, please, one by one, sir. Raise your hands. Raise your hands. Raise your hands. So that we can follow that. Sir, Mr. Malaya Akula.
Yes, Mr. Malaya.
Agreement of sale, is that required both the parties like vendor and vendee's signature or only vendor signature, sir?
Sir, actually, normally agreement of sale or your sale deed is executed only by the vendor. But now to be on the safe side, both the vendor and vendee sign. It's not necessary that both should sign, sir.
Thank you, sir.
Welcome.
sir, can't it be validated after the stamp duty, sir?
Sir,
Later?
validation can be done only regarding the deficit stamp duty and the penalty being collected. But as far as registration is concerned, it cannot be validated. It can be a piece of paper which can be looked into for a collateral purpose, not for the main purpose.
99% of the agreements are written on like that only.
Yes, sir. Sada Bainama in Telangana, sir. It is being validated by paying in the treasury the stamp duty, which is leviable. It is perfectly valid. It can be offered as security also.
What are the precautions to be taken in a agreement of sale regarding the heirs of the property?
Sir, in that, if you want to take the precautions, you'll have to find out whether it's a self-acquired property or a coparcenary or ancestral property. And preferable to take the signatures of the legal heirs as witnesses, or sakshulu, as you call it.
There are minors and about Muslim properties are.
As far as Muslim properties are concerned, the guardian, sir. Muslim property normally, the question is, there are three lines of succession, inheritance there, sir. Sharers, residuaries, and distant kindred. Sharers is people who come as in the form of sons and daughters or whatever it is. Residuaries means vagera vagera. That is people who come from the next generation. Distant kindred means born of the same uterus but of different fathers. That is called distant kindred.
Sir, anything you come across with the Telugu stamps cases, anything you come across where it is that forced documents came into the picture?
Lots of documents came, sir. Most of the documents which
what
came,
happened to them?
yes, sir. Most of the
What
documents
courts?
which came was in Bongir, sir. That is Naeem or someone was the.
Yes. Yes,
but
sir.
still, people are suffering, sir. They have not been corrected till now.
Because if you permit, I'll tell you 2 minutes about that case.
Yes, sir.
Telugu stamp case. Fortunately, I was God blessing. My successor inspector went to jail.
Yeah.
My successor and predecessor, both as inspectors went to the jail for a year. DCP was sent to the jail, and another 1 or 2 inspectors went to the jail,
Right.
having taken bribe from Telugu.
Yes, sir.
So what he has done is entire government forged documents he has used,
Yes.
but simply he has written a diary. He used to click a notebook,
Right.
and whichever he bribe gives to the officers, he used to just write the names.
Right.
Finally, they were not put in the court, but they have to suffer the officers in the jail for 1.5 years. Finally, they were acquitted because the Jain diary and these Telugu diaries will not be, very
Sir, that was
interesting and a dangerous man.
Yes, sir. That was a nexus between the politicians and some police officials, sir. I don't name everyone, but there is a
Yeah.
particular advocate also was a kingpin to that. And he also
Yes,
went there for 10 to 15 days. I don't want to give out his name. He's a leading advocate in Bongare.
Yes. One bigwig, I'll tell you, sir, about the name. One of the DGP was also involved.
Yes, sir.
Because of a DGP, he could get over, sir.
But thanks to
So
Telgi's
that is-
yes, sir. Thanks
But
to,
poor inspector and DSP and DCP went to the jail.
sir, thanks to Telgi scam, today we are getting it endorsed on the reverse. We do not know which is genuine and which is not genuine, sir, because non-genuine looks more than genuine actually.
Yes.
I think color Xerox also that was there. I think that was the case of Ramakrishna Reddy.
Yes.
That is Ramakrishna Reddy from
Oh.
Siddipet.
Yes,
And he
one
was one of-
fellow, some Karnataka fellow, in task force arrested him.
Yes, sir.
When they went and arrested him, entire room was filled up with the old documents, old notaries, all the stamps of tahsildars, doctors, seals, revenue inspectors. He was having all forged. Hundreds of documents will be supplied.
Sir,
And
as
he
far-
was telling in the entire, even a certain authority, what are the illegal documents and who has given, who has utilized them in Bandar Isles and Jubilees. Half of them were illegal.
Sir, you say they తెలుగులో ఒకటి అంటారండి దొరికితే దొంగ దొరకకపోతే దొరండి.
But he was not having any money, simple, nothing found, no luxury, simple life. But he is giving for 50 rupees, 200 rupees, 300 rupees for top.
All right, Muralidhar. Anybody else, sir?
Yes, thank you.
Welcome.
Sir, this
Satyanarayana garu.
yes, AGPA validity time is there, sir. Any validity
Sir,
for
there
that
is
time?
no validity, sir. Normally, AGPA 3 years, sir. Beyond 3
3
years,
years.
it has no value. But if no time is fixed, then it is 3 years from the date of refusal.
Oh.
That's
Suppose
why.
if
That's
the
why.
one-
That's why we use a word. The vendor hereby agrees to sell and execute and register the sale deed as and when called upon by the vendee. So that means it is indefinite. So we come under 54(1) proviso to save limitation. What we do as advocates is we give a notice to the other side. The other side becomes complacent. He does not give a reply. So you get a fresh period of 3 years.
3 years.
3 years from the date of refusal.
Suppose if the AGPA given the person who has died, suppose died, and this man can sell, no? AGPA holder can sell.
He says
land.
because I take you to section 202 to 217 of the Contract Act. That is what is called
Yes, sir.
agency by necessity. Even if the principal dies, the power of attorney remains. Why? Because the power of attorney is not only the power of attorney, but is also the authorized representative of the principal, and interest in the property also is passed on to him. You take the case of a development agreement. In the case of development agreement, 60% goes to the developer and 40%
Yes.
goes to the owner. So that 60% he
Yes.
has got right. He has acquired rights over the property. So the question is, he does not lose his rights as a power of attorney, sir. That is agency by necessity.
If the suppose if agreement of sale come general power of attorney, the man who has given his died also, no problem. Once
Even
he
then,
got
the
it,
power of attorney stands.
stands
If,
good and he can sell the property
yeah, he can do it as a nominee.
as a nominee because he got the
Rights.
AGPA
Yeah.
agreement of sale come general power of attorney.
Which was not revoked.
Not revoked.
Yeah.
At the time of his death, it was not revoked.
If it's not revoked, the interest survives. If he has acquired interest over the immovable property.
Yes, sir. That's what
Anybody else, sir?
I come up.
Sir, good evening, sir.
Good evening.
Please
Sir,
mention your
actually,
name,
I
sir.
have.
Mr. Mohit.
Yeah, actually, yes, sir. Good evening. So I just have a doubt with regards to one of the titles, sir. So once the title has been from ancestral come to grandson, from grandmother to the title transfers to through
Succession.
will. Yeah, exactly. Registered will.
Yeah.
So through registered will, so it got transferred to from his mother to son, and later son has transferred to his son.
Right.
So whether this title is clean, sir, with regards to the will, because both the wills has been registered under in the
So are the
it got
Hindus?
registered
Are the Hindus or Muslims?
in Hindu, sir.
If they're Hindus, it's definitely valid, sir. It comes into effect after the demise, not before that.
Yes, sir. Actually, yeah, the grandmother who has transferred the property, got demise
To his daughter.
Grandmother, sir. Now the grandson got the property, sir.
Grandmother is no more now.
Yes, sir.
Then the boy gets the absolute rights over the property.
Okay, sir. And with regard to the title, so because the transfer has not been made, sir, so the title would be clear, sir, because the title will be still the document.
No, the question is based on the will, he must get that property mutated in his name in the municipal records.
Municipal records, okay.
Yeah. That will give him title.
Okay. Municipal records will give him title, not the registration, right, sir?
No, sir.
Do he need to go and register the fresh document?
Not necessary, sir. You can get it mutated in your name by virtue of that will.
Will, okay. And when he is he want to sell it, so based on the older title and the will, so he will execute the sale, sir.
Exactly, sir.
Okay, sir. Thank you, sir.
Thank you, Mr. Mohinji. Mr. Avinash.
Sir, good evening, sir.
Good evening.
Sir, I was not available today. Sorry, sir.
That's
okay. You can see in the YouTube, sir.
Yes, sir.
All right,
sir. My doubt is, son purchased a property and father made an agreement of sale. Son living in USA, father made an agreement of sale. Now denying to come forward to sell the property. And mentioned in the agreement of sale, father mentioned the name of son and saying that I am his legal representative. I am selling this property for a sale consideration. Now neither son nor father is coming forward after taking entire sale consideration.
You do one thing, make both the father and son responsible, or make them defendants, and ask for a joint execution and registration of the sale by both of them, and also mention the fraud paid by them.
Yes, sir. Already made, sir.
And you can also say the law of agency has come into the work. The question is, the son or father, whomsoever it is, he is the agent of his father.
Perfect.
Yes, sir.
That is agency by necessity.
Agency by necessity can be invoked here, sir.
Exactly.
Yes, absolutely, sir.
202 of the Contracts Act.
202 of the contract. Yes, sir. Same. That was my doubt. Whether rightly or not, whether my conscience.
Sir, 1 second, sir. Let him complete his
property is ancestral or is the father's property?
It's a son's property. Son purchased the property from third party, and son living in USA. Father came into the agreement. Father made the agreement of sale on behalf of son.
Right.
And father signed the agreement of sale for son.
Sir, the question is whether the father had a GPA of his son.
He says that he has GPA, but he never showed that GPA.
Even if the GPA is there, the GPA has to be registered compulsorily, sir. Unless the GPA is registered, there is no question of passing of title.
No, sir. That GPA, he has just shown that GPA. In that GPA, it is only for operating the bank accounts and lockers.
Then
That's unregistered GPA.
Unregistered GPA means it's not enforceable. As far as the agreement of sale is concerned, you must make the son responsible.
I made both of them parties, sir, father and son.
That's a safer approach.
Yes, sir.
Sir, anybody else?
Sir.
Sajnani garu cheppandi.
Sir, Santhanam sir, suppose HMDA layout, sir, final approved layout is there. One man has purchased a plot in that. And subsequently, after some time, there was a dispute in the legal, that is documents.
Right.
What is the role of the HMDA in this?
HMDA is definitely liable because they are bound under the layout only. If they have given a false document to you, then the HMDA can be made responsible for it.
How many floors of building it is there?
I think you are
How many floors of building it is?
No, it is only open plots.
I think you are referring to Upal Bhagat.
Not sir, this is in near Bibinagar, that is Ames.
That is Bhubaneswar, you meant to say that.
Not even Bhubaneswar, it is Bibinagar, opposite to the station side, that side. It was all the property.
It's also
final layout.
Bibinagar side, all are fallow lands only. There is no construction there.
What is supposed if somebody has come and claimed again that HMDA the plants are
Sir,
mine,
now I would like
property is
to.
mine and HMDA is given wrongly the
Or
sanction,
you do one
then,
thing in case you want to go
we
for.
can put a case against the HMDA, sir.
Sir, is it notarized, sir?
Is it notarized land, sir? What you're speaking about?
Not notarized. It is clear sale deed land.
It's a
If you
clear
say
sale deed.
sale deed, or you do one thing. You file an action against HMDA itself for declaration that you are the owner.
That's what actually I'm asking, sir. Role of HMDA.
Yeah,
So
role of
HMDA
HMDA
is
is
also
once
a
they have
responsible.
executed the sale
HMDA
deed,
also another part.
they cannot go back on that.
Open plot.
So they have
How
to
big
do
is the
it.
area, sir?
Yes.
How big is the area?
That is 1200 yards.
1200
That
yards.
is, of course, they made it 3 plots,
Achha.
400 each.
400 each. Okay. Now the construction is going on which place? I mean,
No construction. Still, recently they have given the final approval.
okay. Now HMDA can be made as a party, and you can even approach to the RERA also to make it a blacklisted. So
Yes.
why? Because if the HMDA is doing some nonsense, RERA will take an appropriate action towards HMDA also.
Yes.
Both are interlinked.
And the purchaser has already got it registered through the landowner.
That's
But,
what, both are interlinked.
There was a dispute in the land, but HMDA could not look into that.
Sir, HMDA is much maligned, sir, by the previous government. I think you know people were also arrested. There was irregularities also committed by HMDA.
yes.
That is the reason HMDA is not even bothered to look up your cases, sir. I mean, a lot of negligence is going on there.
Balakrishna, he was arrested.
Exactly, sir.
For giving false.
Or the unaccounted money of some people were with him.
Sir, please.
I don't want to say about it.
Please.
But one thing, lot of things said about HMDA, sir. And especially if you have seen the East City, none of the plots are sold. No person has constructed.
Those are all almost
Bhudan lands.
Yes, Bhudan. Of course, that is a Narne estate.
Narne Bhaskara. Narne Rangarao.
So now we can take a party. HMDA is a party.
Definitely you can do so.
You can even make a party of RERA also. I request you to do that also. If RERA comes into the scene, HMDA will come to your control.
Yes.
Because RERA, once HMDA gets an approval,
yes.
Once HMDA gives an approval, if any kind of skeleton beyond, because you are saying about 1200 square yards,
yes,
definitely they need an approval of RERA. When HMDA is not giving any appropriate reaction from them, then RERA will come into the scene. The scene, what you say, will definitely conflict them. Definitely, you are making a fight between RERA and HMDA.
Even 200 square yards also they are responsible, no, sir?
No. If it is 200 square yards, and how can I expect it, sir? Maybe HMDA will come into that again. It will come planning will come again.
HMDA has given approval for this entire layout. In that, some 167 also is there.
167 is now. Then you need to go to planning and development again. That's a different
but they are responsible now. But
HMDA will be one of the party. HMDA will be one of the party. Again, the planning development who is giving approvals for the land. GHMC will be another involved, and the MRO will be involved. Everybody will be a party.
Yes. So we can go with them. We need not only go with the party. We can go with these government departments.
That's what everybody will be a dependent into your plane. Definitely.
You can definitely make you can also make a representation to the Praja Bhavan, sir, because they are interested in getting such.
Sir, Praja Bhavan, छोड़ो sir, अभी घूरी मारो,
because
अभी कुछ नहीं आने
That is a dream, sir.
They are trying to they are trying to fix up the HMD officials of the previous regime, sir.
No, I seriously, there are some actions going in Praja Bhavan, but still it is in a very premature to comment upon it.
That is all. LRS only they could not. They collected 1,000 rupees for each plot, and they could not fix the rate. And
so many people are even paid the amount also.
25 lakh applications are pending.
What to do, sir?
With 1,000 rupees fees.
All right, Sachinandgar, 1 second. I'll come again to you. Miss Priya, please go ahead with your question. Priya Garu, please unmute yourself and you can go ahead with the questions.
Sir, am I audible?
Yeah, you're audible, ma'am. Please go ahead.
Namaste, sir.
Namaskaram.
Sir, I wish to ask you a question of the subject, like more specifically related to family law or Hindu Marriage Act, sir.
Yes.
May I?
Yeah.
Please go ahead.
Sir, is there any limitation period for filing the petition for RCR, sir?
That is restriction
Or,
of conjugal
is there
rights.
1 year period of limitation for filing RCR?
No, sir. There is no, madam. There is no limitation for any of the reliefs under the Family Courts Act and HM Act. There is no limitation, madam.
Fine, sir. Thank you.
Okay.
So you mean to say Section 29 of Limitation Act applies to Hindu Marriage Act?
No, madam. You can file it at any time.
So, but I have read it somewhere like there's 1 year period of limitation for filing RCR.
But please remember, madam, please don't try to enlighten the courts, because the courts are entertaining it even after that period. Your other sister advocates will be affected. Better
Yes.
Sometimes there's a saying, ignorance is bliss.
Sure, sir. Thank you. But I have read it somewhere. So,
If you have read it, please
don't
don't tell the judges, madam.
Yes,
sir. Sure, sir. Thank you so much.
All right. Any more questions?
Sir, if the RCR given also, if they are not responded for more than 1 year,
Then the question is, then you have to only take it as a certificate and file for divorce.
That's all.
That's all. There's no other thing. But they say order 21 to 32 is there. That is Sarita's case. It can be executed. But how can you forcibly get that lady and then ask her to stay with you, sir? Very difficult. They may stay under the same roof. But whether conjugal rights has been restored or not, only God knows. Judge will not come and inspect every day and find out whether they're staying in the same home or not.
Suppose she has not come to, after RCR also she has not come.
Perhaps you have not come
Sir,
perhaps you have not come to such a stage where a commissioner is appointed to make a local inspection and give a report.
Sir, in one case.
Sir. Please give a chance to some other people. Sir, Balkrishna, Murli Garu and other people. Inkold never know question. Let us. Manam Monday maatadukundam in the same port. In the same port. Manam evarna questions unte please go ahead.
మన కరికులంలో ఇది కూడా హిందూ మ్యారేజ్ యాక్ట్ ఉందా సార్?
ఉంది సార్.
ఓకే.
ఉంది సార్. ఒక 5 నిమిషాలు సార్. విల్ కమ్ బ్యాక్ అగైన్. మళ్ళీ మాట్లాడుకుందాం. అదర్ పీపుల్ ఒకసారి ఏమైనా క్వశ్చన్స్ ఉంటే ప్లీజ్ గో అహెడ్ సార్.
సార్ గుడ్ ఈవినింగ్ సార్.
గుడ్ ఈవినింగ్
సార్ ప్లీజ్ సార్ మీ పేరు గెలాక్సీ M30 అంటే నాకు కొంచెం ఇబ్బందిగా ఉంది. మీ పేరు చెప్తారా?
సారీ మై నేమ్ ఇస్ నిఖిల్ సార్. I met K.Santhanam sir in the Secunderabad.
Yeah, I remember. Yes.
Mr. Nikhil.
Yeah.
Ganesh Gari Junior.
Yes.
Absolutely. Now you come to the place.
Yes, sir. I have one small doubt, sir. My friend's father was recently expired.
Right.
So his father doesn't return any will, sir.
Right.
So he's a government employee.
Right.
My friends want to sell that plant, sir.
Right.
Any suggestions for that?
Sir, the question is the property is in intestate succession, sir. The question is you will have to ask for a succession in respect of that property, immovable property, by filing a suit for declaration, saying that you are all the legal heirs. You will be declared as the for the legal status as the sons and daughters of X, whatever it is, because he has died intestate. Are they Hindus or Christians, sir?
They are Christians, sir.
If they are Christians, Indian Succession Act applies. Section 36 to 37 of the Indian Succession Act says all of them are entitled to equal shares, sir.
Okay. But his mother can't walk, sir. Shall she come?
She need not come, sir. She can execute a GPA in favor of one of the sons or so.
That too only for the court and court appearance, not for everything.
Thank you, sir. Thank you very much.
Welcome.
All right. Anybody else? Please go ahead with your questions. We are here to solve it.
Good evening, sir.
Good evening.
Madam, Zoom user, please name it.
I'm Shailaja, sir.
Please come.
Sir, what happens if a person dies after giving GPA, sir? Does it exist? Or
no, I told you, madam. Actually, 202 of the Contracts Act says if the GPA holder acquires an interest in immovable property, even if the principal dies, the interest survives. That is mostly in the case of development agreement or development cum construction agreement. In that, the GPA gets 60% and the owner gets 40%. The question is, even if the principal goes, it is called an agency by necessity. The GPA doesn't get extinguished. You can go through section 202 to 217 of the Contracts Act.
Thank you.
Any more questions? Or can we call for a day? Any more questions?
Sir, namaste.
Namaste. Nagachandram garu, please go ahead.
Sir, chinna doubt, sir.
How's he today late in asking questions, sir?
Sir, sir, ఇప్పుడు SRO నారపల్లి గారు SRO నారపల్లి.
Yes, sir.
రిఫ్యూజల్ నోటీస్ పంపించారు సార్ రిజిస్ట్రేషన్ చేపిస్తే.
Right.
అయితే దానికి ఒక G2/257 జీవో అడ్డం పెట్టి రిఫ్యూజల్ నోటీస్ పంపించారు.
Yes.
అది దానికి కామన్ ఆర్డర్ కూడా హైకోర్టు ఇచ్చారు. ఆ కామన్ ఆర్డర్ చూపించినప్పటికీ నేను చేయలేను, నేను రిజిస్ట్రేషన్ కంటిన్యూ చేయలేను, ఇది పర్మిషన్ లేదు అంటాడు. పర్మిషన్ గ్రామ పంచాయతీ పర్మిషన్ ఉన్నది, లేఅవుట్ కూడా గ్రామ పంచాయతీ పర్మిషన్ ఉన్నది. దాని పక్క ఫ్లాట్ ఆల్రెడీ సెకండ్ ఫ్లోర్ లో, థర్డ్ ఫ్లోర్ లో 302 ఆల్రెడీ రిజిస్టర్డ్, బట్ 301 రిజిస్టర్ చేయమంటే చేస్తలేదు.
సార్ ఇక్కడ మీరు ఎన్ని పర్మిషన్ తీసుకున్నారు? హౌ మచ్ ద పర్మిషన్ ఇస్ బీన్ టేకెన్ ఫ్రమ్ ద గ్రామ పంచాయత్?
అది +3 అని ఉన్నది.
+3 ఉన్నది. స్టిల్ ఇందులో 2 విషయాలు ఉన్నాయి మేడం. +3 తీసుకున్నది వీళ్ళు తీసుకున్నది దేనికి? పిల్లర్ ఇన్స్పెక్షన్
థర్డ్ ఫ్లోర్ 302 తీసుకున్నారు వీళ్ళు. 302 ఆల్రెడీ రిజిస్టర్డ్, 301 రిజిస్టర్డ్ అప్లై చేస్తే రిజిస్ట్రేషన్
చేయలేమంటున్నారు కదా.
రిఫ్యూజల్ నోటీస్ పంపించారు.
ఒకటి ఇంకా 2 విషయాలు ఉన్నాయి. ఇస్ ఇట్ స్టిల్ అంటే దీన్ని ఏమంటారంటే జిహెచ్ఎంసీ వాళ్ళకి కానీ గ్రామ పంచాయతీ వాళ్ళకి కానీ కొన్ని రాసి ఇస్తారు సార్ వాళ్ళు. టిల్ ద లోన్ ఏదైనా ఉన్నా సరే అది క్లియర్ ఆఫ్ చేయడానికి దాన్ని ప్లెడ్జ్ చేసి పెడతారు.
ఆల్రెడీ దీని పక్క ఫ్లాట్ అయిపోయింది రిజిస్ట్రేషన్.
ఇప్పుడు ఎన్ని ఫ్లాట్స్ ఉన్నాయి మొత్తం? ఎన్ని ఫ్లాట్స్ ఉన్నాయి మొత్తం?
15 years back. 15 years back.
15 years?
15 years back apartment.
15 ఏళ్ళదా?
Sir, one thing you can do, sir. You can file a writ petition in the High Court against the refusal by the sub-registrar to register the document when the neighbor's flat could be done. Why not register my flat?
Till the court orders, it can be registered.
Yeah. And pending the court orders, it can be registered, sir. Court can give a conditional order also. Best is to go to the High Court.
Already writ petition also filed, sir.
Right.
Writ petition
also filed.
You take an interim direction to register the flat.
As per the
pending disposal of the writ.
Till the court orders and registration change court, sir.
Sir. Thank you, sir. Thank you very much.
Any more questions? Please go ahead.
Sir. Namaste, sir. Good evening, sir.
Rudra. Mr. Rudra, please go ahead.
Sir, Rudra from Vijayawada.
No, sir. I am from Telangana, sir, of Sangareddy district.
Okay, sir.
Jahirabad, sir.
Right, sir.
A small doubt, sir. Clarification to sir.
Right.
Earlier, sir, మనకు చిన్న కేసు వచ్చాది. 1972 లో గవర్నమెంట్ ఎంప్లాయీ సొసైటీకి ల్యాండ్ ఇచ్చారు 9 acres.
Right.
మున్సిపాలిటీ వాళ్ళు రిజిస్ట్రేషన్ చేసి గిఫ్ట్ చేసి ఇచ్చారు ఫర్ ఓన్లీ ఎంప్లాయీస్ పర్పస్.
ఎంప్లాయీస్ సార్?
గవర్నమెంట్ ఎంప్లాయీ సార్.
అలా కాదు సార్, గవర్నమెంట్ ఎంప్లాయీస్ ఎనీ స్పెసిఫిక్ సెగ్మెంట్ ఇచ్చారా?
సారీ ఫర్ ద డిస్టర్బ్ సార్.
ఎనీ స్పెసిఫిక్ గా ఒక గవర్నమెంట్ ఎంప్లాయీ అంటే దేనికి ఇచ్చారని మీరు చెప్పగలరా?
ఎనీ ఎంప్లాయీస్ కి, నాన్ గెస్టెడ్ ఎంప్లాయీస్ కి అందులో ప్లాట్స్ ప్రొవైడ్ చేయడానికి ఇచ్చారు సార్. ఇస్తే అందులో ఆల్ 72 నుండి ఇప్పటి వరకు అందరికి రిజిస్టర్ చేసి ఇచ్చారు. గిఫ్ట్ డీడ్ అండ్ కన్వీన్స్ డీడ్, ఆల్ వెరైటీస్ డీడ్, ఓసారి గిఫ్ట్ ఓసారి కన్వీన్స్ ఇలా చేసి ఇచ్చారు. చివరికి ఏంటంటే కొద్దిగా ప్లేస్ మిగిలింది సార్, కొద్దిగా ప్లేస్ మిగిలింది సార్. ఆ ప్లేస్ ఈ ఎదుటి వాళ్ళకి ఒక లైన్ ఉంటుంది కదా సార్, ఒక లైన్ ఒక వీధి వచ్చేసి ముంగట వాళ్ళకి 60 feet రోడ్ అని రిజిస్ట్రేషన్ చేసి ఇచ్చారు వాళ్ళకి.
ఓకే.
తర్వాత ముంగట కొద్ది ప్లేస్ ఉంటే దాన్ని తగ్గించి మళ్ళీ ముందు వాళ్ళకి
36 ఫీట్స్ రోడ్ అని చేసి
సరే
మళ్ళీ వాళ్ళకి రిజిస్ట్రేషన్ చేసి ఇచ్చారు.
సరే
అంటే ఇందులో సార్ అది ఎవరి ల్యాండ్ వాళ్ళకు ఉంది, ఎవరి ఫ్లాట్స్ వాళ్ళకు ఉన్నాయి. రోడ్ అనేది 16 నుండి 36 ఫీట్ కి వచ్చారు. అది డెడ్ ఎండ్ రోడ్ ఉన్నది సార్, డెడ్ ఎండ్ రోడ్ ఉన్నది. ఇప్పుడు ముందు వాళ్ళు ఏమంటున్నారంటే లేదు మాకు 60 ఫీట్ల రోడ్ ఉంది, 60 మీకు వచ్చేసి 36 ఫీట్స్ ఉంది మా ఇద్దరి మధ్యన అని ముందు వాళ్ళు కొద్దిగా అబ్జెక్షన్ చేస్తున్నారు సార్. 60 అని రిజిస్టర్. హౌ టు అప్రోచ్ టు సార్? ఆల్రెడీ దానిలో హైకోర్టు జడ్జిమెంట్స్ కూడా ఉన్నాయి సార్. ఏంటంటే ఈ 9 acres ల్యాండ్ సొసైటీ వాళ్ళదని 2-3 సార్లు 2-3 times.
Mr. Rudra, why don't you send the Xerox copy of the document to my admin, sir, so that I can go through it and then give you proper reply to that.
Sir, మీకు మెయిల్ ఐడి మీకు పంపిస్తున్నాను.
సార్
ఇన్ చాట్ బాక్స్ లో అందరికి పెడుతున్నాను. ఎనీ టైప్ ఆఫ్ doubts you have, please mail your doubts and ring me up on my number so that మేము అది చూసి మీకు రిప్లై మేము ఇస్తాం.
ఓకే సార్,
మీకు చాట్ బాక్స్ లో పెట్టాను చూడండి సార్. మై మెయిల్ ఐడి అండ్ ఈవెన్ మై మొబైల్ నెంబర్ ఆల్సో.
తప్పకుండా సార్.
ఈ రెండింటిలో మీరు మొబైల్ మీరు ఏమంటారంటే మెయిల్ చేయండి డాక్యుమెంట్స్ అండ్ గివ్ మీ అ కాల్ సో దట్ ఐ విల్ ఆన్సర్ యువర్ క్వైరీస్ వాట్ ఎవర్ ఇట్ ఇస్.
ఓకే సార్.
థ్యాంక్ యూ. అండ్ ఎనీ మోర్ క్వశ్చన్స్ ప్లీజ్ గో హెడ్ సార్. Sir, any more questions from an audience? Any topic? Alam sir. Abdul Alam. Any more questions? Are we done for today? All right, sir. What is on? Murali garu, meer em maatladutunna, then go ahead with your questions.
So tomorrow we'll be continuing with the second document, which I will propose to take is the case of mortgage deed. How a mortgage deed is made, because that's quite a lengthy one. Because there are 6 types of mortgages: simple mortgage, mortgage by conditional sale, usufructory mortgage, English mortgage, anomalous mortgage, and mortgage by deposit of title deeds. But please bear it in mind, you are all professionals. Don't draft anomalous documents because you will become anomalous. I think you know the meaning of anomalous. That is neither a male nor a female. A transgender.
All right. Any more questions, sir? Please go ahead. Otherwise, we'll wind up for today. Or Muralidhar Balagaru, you have any questions now? You can go ahead with the discussion, as earlier was little bit diverted. Sachinand garu unte meer kuda maatladukochu.
Sir, excuse me, sir.
Yeah.
Please. Category Srinivas.
No questions. I was just wanted to talk. Nothing. Thanks a lot.
Welcome, sir.
Srinivas garu cheppandi.
Sir, ప్రభుత్వము పేదల కోసము భూమి పంపిణీ చేయడం కోసము ఒక 10 ఎకరాల భూమిని తీసుకున్నది. తీసుకొని అందరికి 200 గజాల చొప్పున పనిచేసింది. పంచంగా మనిషికి కొంచెం పక్కన ఇల్లు అంటే ఏదైతే ల్యాండ్ ఇచ్చిందో దాని పక్కన కొంచెం ప్లేస్ మిగిలింది. అంటే 20 గజాలు 10 గజాలు అట్లా మిగిలింది. ఆ 200 గజాలు ఇచ్చిన వాళ్లకు ఆ 10 గజాలు 20 గజాలు కలుపుకొని కట్టుకునే అధికారం ఉంటుందా సార్?
లేదండి,
లేదా సార్?
ఎనీ టైమ్ ద గవర్నమెంట్ కెన్ చేంజ్ ఇట్స్ మైండ్ ఆల్సో. ఇట్స్ ఎ రిస్కీ ప్రాపోజిషన్.
మా పక్కన ఉంది కదా మేము కలుపుకుంటామని
కావాలంటే మన ఇది చెట్లు పెంచండి, హరితహారం.
తెలంగాణలో సార్ సార్ అది తెలంగాణలో ఏదైతే ఈ ల్యాండ్ కబ్జా అంటున్నాడు కదా సార్, ఇంతకుముందు సార్ చెప్పాడు కదా 10 గజాలు 20 గజాలు, అందులో ఒక బిల్డింగ్ కడితే పోయిన గత ప్రభుత్వము బిఆర్ఎస్ స్కీమ్ పెట్టింది కదా సార్,
రెగ్యులరైజేషన్ స్కీమ్.
అవునా సార్, బిఆర్ఎస్ అని బిల్డింగ్ రెగ్యులరైజ్ స్కీమ్ అని చెప్పి అందులో ఈ ఏదైతే మార్కెట్ వాల్యూలో 50% కట్టేసి రెగ్యులరైజ్ చేసుకోవచ్చు అని అప్పుడు అప్లికేషన్ తీసుకున్నారు.
ఈ present government will not do it, sir, because I tell you, I think there are political considerations also. But to mop up revenue, they may do it. I'm not ruling it out.
Already previous government already online applied to apply, sir, Telangana public. Already applied online application.
Sir, it's absolutely a political issue, sir. Previous government ఏదైతే చేస్తుందో ఈ government will not follow it unless they want to mop up revenue and money for the state treasury, sir.
Sir, okay.
Sir, sorry to interrupt, sir.
Yeah.
But if a person is staying in the same house for 20 plus years, is eligible to.
See, not 20, sir. It is 12 years is enough. Adverse position.
Okay. So in this case, it is applicable, sir.
No, sir, not so. You can definitely go by legal action. No one disputes it. But the question is, adverse position can cut you both sides. It should be continuous position. There should be an uninterrupted position, and no one should disturb you from position. And that's why it said position is 9 points of title in jurisprudence. But 1 point, the paramount title vests with the government. So once that 1 point comes, the 99 points goes.
Mr. Vasantrao garu.
Sir. లావణి పట్టాలు వాళ్ళు సేల్ చేయొచ్చా?
Sir, Lavanya Patta అనేది Leoni Patta. So it's not Lavanya Patta. In Telugu, these people pronounce it as Lavanya Patta. There is one candidate by name Lavanya also among yourself. But Leoni, it's not Lavanya. Laoni. That is assigned land. Even Ramoji Rao's film city is also assigned land, Abdullapur Met. But the government now, present government is adopting an attitude of regularizing all assigned lands, please.
It is sellable, sir.
Once it is relaxed and patta is given, it can be sold. But actually, Lavanya Patta or something, only the restriction is for 10 years. With the permission of the collector, you can sell it.
Without permission, you cannot sell.
No. But Abdullapur Met is also an assigned land where the film city is located.
All right, Mr. Vasantrao garu, please go ahead. Any questions you have, or otherwise Chakravarti garu is there? Sharma. Ramchandran garu.
Sir, I am Sri Ramchandramurthy from Vijayawada, sir.
Please go ahead, sir.
Sir, I want to know how can we come to know about double registration?
Sir, you will have to go. You will have to. Yes. Go ahead.
Came to know all double registrations are going on. So how can we know whether our property has been previously registered or not? This is all.
Yes, sir. That is the reason why we give a public notice in a newspaper calling upon people to give their objections. And if not, you say that the transaction will be completed. Then you go to the registrar office, verify the register. That is what is called for sale deed. It's book 1. You can definitely go through the register and take a certified copy of all the transactions in respect of book 1, sir. EC, but no importance can be given to EC, sir, because unless it's a registered document, it will not be entered in the EC.
Yes. So nowadays, registration can be made at any register office, sir. That is why I am asking, sir.
No, sir. That I think now that has been discontinued. Previously, it was there. It is abolished now.
Achha.
Previously, it is supposed to do. Now it is totally abolished. Within the jurisdiction, within the SRO jurisdiction only, they are able to do the registration.
As you said, these frauds take place when you do it in different registrars' offices.
Yes, sir.
Again, a GPA, whatever now the fraudulent things are happening, most probably by the GPA holder, AGP holders only. So, if an AGP or a GPA has been given, definitely it has to be registered. Otherwise, GPA or AGP is not valid at all. The new rulings.
So you ask a GPA holder, you ask that Anta Manade Ankontada. You think that the entire land belongs to me. I still remember I stayed in Markpalli, sir. There was one Dr. Iyengar. He said, of course, my father was the person who wrote the document. Stones, shrubs, grass, and then water, pebbles are found, all belongs to me. And it entered in a controversy. That is survey number 74. And two of the societies, for example, Ravi Cooperative Society and Baramrai Society, which is managed by one industrialist who is a prominent member of the BJP. The question is, there all the disputes started there. I still remember those two societies, Balam Rai Society and Ravi Cooperative Society, including my society, Nehru Nagar Society also is in doldrums. No document is being registered unless you take the permission from the High Court by filing a writ petition.
Sriramurthy garu, for an example, there is a property issue going on here in our office itself. A total Mahendra Hills, which is called as backward area,
slums.
Slums. The only IAS IPF's officer stays there. Okay, each building is not less than 500 square yards, and everybody who is staying over there are registered document. Again, Rudragar, as you said, only by court orders only the registration is done again. And again, if the court orders gives you certain kind of obligation saying that your registration is not valid, they have to vacate it. For the last 50 years, same building is going on, they're staying happily.
You are practicing in Vijayawada, sir?
Yes, he's practicing.
Yes, sir.
Civil court?
Civil court, sir. Civil side.
We'll be seeing you on 30th.
So we have a lecture coming up in July 30th about art of cross-examination. As I spoke to Bar Association President Garu, and we are glad to saying that he is permitted us, and we are coming with full-fledged. At 12 o'clock, we are having that.
Sir, nowadays SROs, sir, any property has will be registered, sir. Due to revenue, అంటే గవర్నమెంట్ కి రెవెన్యూ కావాలి కదా సార్.
రెవెన్యూ కావాలని మీరు ఒక పాయింట్ ఆఫ్ వ్యూ చెప్పింది కరెక్టే సార్, కానీ ఏంటంటే విత్ ఇన్ ది జ్యూరిస్డిక్షన్ అయితేనే చేస్తున్నారు. అవుట్ ఆఫ్ ది
చేస్తారు సార్. అదేంటంటే ఇప్పుడు అక్కడ ప్రాపర్టీ ఉందా లేదా
ఇప్పుడు మా దగ్గర
actually that is one of the complaints or grievances on the Dharani. What happened was there are only 3 columns or 4 columns now. The name of the person who is in possession has not been mentioned. So many problems are there. The question is Dharani is being scrapped. Dharani is being scrapped.
One question, sir. Government is instruction to the SRO, sir. ఎందుకంటే రెవెన్యూ కావాలి, ఏమైనా చేయండి, ఏ రిజిస్ట్రేషన్ చేయండి, వాళ్ళు కోర్టుకు పోతారు. మీరు
చెప్పేది ఎట్లుందంటే ఒక 10 ఫామ్ హౌస్లు కట్టుకుంటానండి వేరేలా.
చక్రవర్తి గారు, ఇందాక శ్రీరామూర్తి గారు ఎందుకు క్వశ్చన్ అడిగారు. ఆయన ఏమన్నారంటే డబుల్ రిజిస్ట్రేషన్ ఎలా కనిపెట్టాలి సార్. డబుల్ రిజిస్ట్రేషన్ కనిపెట్టడం చాలా పాసిబిలిటీస్ చాలా తక్కువ ఉన్నాయి రిమోట్ లో. కానీ ఏంటంటే మన ఇంట్రెస్ట్ కొద్ది మనం వెళ్ళాలి, చూసుకోవాలి. దాని ఓన్లీ ఈ రోజు రేపు కొంచెం అటు ఇటుగానే ఉన్నాయి
సార్. డబుల్ రిజిస్ట్రేషన్ సంబంధించి కొన్ని సింపుల్ గైడ్ లైన్స్ ఏదైనా డిటెక్ట్ చేయడానికి ఒక 2-3 పాయింట్ అంటే బికాస్ వీఆర్ డీలింగ్ విత్ బ్యాంక్స్ సార్.
సార్ మీకు ఒక ఎగ్జాంపుల్ చెప్తాను. దర్ ఇస్ అ కేస్ కమ్ అప్ విత్ us. ఈజ్ అ డాక్టర్ బై వైల్ నాట్ నేమ్ హిస్ నేమ్. ఈజ్ అ డాక్టర్. మా దగ్గరికి ఒక సుత్తపూసలాగా వచ్చి కూర్చున్నాడు. కూర్చుని ఏమంటాడంటే, సార్ నాకు స్పెసిఫిక్ పర్ఫార్మెన్స్ ఇవ్వాలి, మీరు వేసి పెట్టండి అని అన్నాడు. డాక్యుమెంట్స్ ఇచ్చాడు, అన్ని ఇచ్చాడు. రెనాల్డ్ బ్యాంక్, గవర్నమెంట్ బ్యాంక్ లో నా ప్రాపర్టీ ఉంది మా దగ్గర. ఒక 300 గజాలు, ఒక 500 గజాలు, ఇంకొక చోట వచ్చి 500 గజాలు, మొత్తం కలిపి ఒక 1300 నుంచి 1500 గజాలు ఉంది సార్ మాది, మీరు రిలీజ్ చేయించాను అన్నాడు. ఏమిట్రా మీరు చేసింది స్పెసిఫిక్ పర్ఫార్మెన్స్ అని అడిగితే, మేము అడిగింది ఎందుకు స్పెసిఫిక్ పర్ఫార్మెన్స్ కూర్చుంటున్నాను అడిగితే మాకు వచ్చిన క్వశ్చన్స్ చెప్తున్నాం సార్. అంటే మన అడ్వకేట్లు పనిచేసే తీరు పద్ధతి బట్టి తెలుస్తే కొన్ని విషయాలు డబుల్ రిజిస్ట్రేషన్ అయ్యే లేదా అని. మా దగ్గరికి వచ్చి సుద్దపూసలకు ఏం మాట్లాడంటే, బ్యాంక్ లో తనఖా ఉంది, నేను ఒక కంపెనీ మొదలు పెట్టాను, ఈ పర్టికులర్ ప్లాట్ తీసుకెళ్లి ఐ కెప్ట్ ఇట్ అట్ దీనిలో పెట్టాను, నేను ప్రైవేట్ మార్ట్గేజ్ లో పెట్టాను. మార్ట్గేజ్ లో పెట్టి నేను నా క్యాపిటల్ తీసుకున్నాను, రన్ చేశాను, షో రన్ చేశాను చెప్పారు. బాగుంది, చాలా బాగుంది ఇది నువ్వు చెప్పింది అని చెప్పేసి అన్ని స్పెసిఫిక్ పర్ఫార్మెన్స్ అన్ని పేపర్లు మాకు రిజిస్టర్డ్ డాక్యుమెంట్స్, డ్యూలీ రిజిస్టర్డ్ డాక్యుమెంట్, డ్యూలీ రిజిస్టర్డ్ ఈసీలో కనబడుతుంది, అన్ని కనబడతాయి, అన్ని పర్ఫెక్ట్ డాక్యుమెంట్స్ చూస్తే మీరు అంటారు ఇది ఖచ్చితంగా ల్యాండ్ ఎగ్జిస్టింగ్ అని, పక్కా అని. మాకు ఎక్కడ డౌట్ వచ్చిందంటే, మరి గవర్నమెంట్ బ్యాంక్ గుడ్డిదైతే కాదు, 4.5 crores ఇచ్చారు సార్. విల్ యూ ఇమాజిన్? 4.5 crores has been given on sanction ఇచ్చారు. నా ప్రాపర్టీ గురించి మా దగ్గరికి వచ్చి స్పెసిఫిక్ పర్ఫార్మెన్స్ వేయమంటే క్లయింట్ ఇచ్చిన మాకు ఇన్పుట్కి మాకు జరుగుతున్న ఇన్పుట్కి మాకు ఎక్కడ దొరకట్లేదు, కొంత ఉండట్లేదు, కనెక్టివిటీ దొరకట్లేదు, డాట్స్ కనెక్ట్ అవ్వట్లేదు. దట్ నో దిస్ కేస్ గాట్ సమ్ కైండ్ ఆఫ్ సార్ కూడా అన్నా నేను, సార్ ఏదో ఈ కేసులో ఏదో మతలబ్ ఉందంటే నేను ఏమన్నానంటే వెళ్ళి వెరిఫై చేసి ఫిజికల్ వెరిఫికేషన్ వెళ్ళి చెయ్యన్నాను. ఏదో మతలబ్ ఉంది సార్, ఎందుకు ఫిజికల్ వెరిఫికేషన్ చెయ్యంటే మేము స్టన్ అయ్యే నిజాలు ఏమొచ్చో తెలుసా సార్, పుట్టుపూర్వత్తాలు అక్కడికి వెళ్ళేటప్పటికి ఒక చిన్న సైజు పెంకుటిల్లు లోపల, ఆ ప్రాపర్టీకి పెద్ద గేట్ మీద చిన్న గోడ మీద దిస్ ప్రాపర్టీ బిలాంగ్స్ టు సో అండ్ సో విత్ ఫోన్ నెంబర్స్, ఇట్ ఈస్ నాట్ ఫర్ సేల్ విత్ ఓఎస్ నెంబర్, with OS number. All the 3 properties are fraudulently registered. Total 1500 square yards is fraudulently registered with the GPA, AGPA holders. లీగల్ ఒపీనియన్ నుంచి బ్యాంక్ లో తీసుకున్నారు. ఎంత పెద్ద ప్రాపర్టీ అంటే నువ్వు ఇప్పుడు బ్యాంక్ దగ్గరికి వెళ్ళాం, మేమే వెళ్ళాం, ఊరే ఓటీఎస్ ఇవ్వరని, ఓటీఎస్ ఇవ్వరని అడిగితే వాడేమన్నాడంటే సార్ నేను ఓటీఎస్ ఇస్తా, ముందు ఎవరైతే పర్చేస్ ఆడు పట్టరా అన్నాడు. వాడు పర్చేసర్ రారా అంటే ఇదిగో వస్తున్నా అన్నాడు. ఇప్పటిదాకా ఫోన్ లేదు సార్, పర్చేసర్ ఇదిగో వస్తున్నా అని చెప్పి ఇప్పటిదాకా రాలే మా దగ్గరికి. అంటే దిక్కుమాల ప్రాపర్టీలు అన్ని ఇలాంటి కొన్ని లిటిగేషన్ వస్తుంటే ఫిజికల్ ఎపీరియన్స్ మనం చేసుకోవాల్సిన అవసరం పడుతున్నది.
అవును సార్, అవును సార్.
అంటే అఫ్ కోర్స్ వీఆర్ విత్ ఇన్ ది సిటీ కాబట్టి మనం ఎక్కడికైనా వెళ్ళి చూడగలుగుతున్నాం. కొంతవరకు మనకి చుట్టుపక్కల ఉన్నది ఒక 10 కిలోమీటర్ రేడియస్ ఉన్నట్టు వెళ్ళి చూడగలుగుతున్నాం. బట్ దే వెన్ అండ్ దేర్ మేము వెళ్ళిన కొన్ని నిజాలకి. అండ్ ఇంకొక విషయం ఇందులో పెద్ద ట్విస్ట్ ఏంటంటే ఈ కేసు మాకు రిఫర్ చేసింది ఒక అడ్వకేట్, అండ్ ఇట్స్ గ్రూప్ ఆఫ్ అడ్వకేట్స్ అగైన్. 12 మంది సిండికేట్ ఉండి, నేను 12 మంది సిండికేట్ ఉండి వాళ్ళకి చేత కాక మరి ఏమిటో మాకు తెలీదు. బ్యాంక్ మేనేజర్ అంటాడు నేను ఓటీఎస్కి రెడీ, నాకు ప్రిన్సిపల్ అమౌంట్ కట్టండి అంటాడు. నువ్వు ల్యాండ్ ఎక్కడ చూపించు అంటాడు నాకు. ఊరి నాయన అక్కడికి వెళ్ళిన తర్వాత మాకు 1960s సేల్ డీడ్స్ చూసాం మేము, 1970s సేల్ డీడ్ విచ్ వాస్ బీన్, ఇది 2000, ఇది పెద్ద న్యూస్ పేపర్ లో పెద్ద ఆర్టికల్ మాకు, ఈనాడు అందులో పేర్లు కూడా రాసినాయి, వద్దు, పేపర్ లో పెద్ద ప్రకటనలు, బ్యాంక్ వాళ్ళు ప్రకటనలు. అంటే ఇది పెద్ద స్కామ్. ఇట్ హస్ బికమ్ అ బ్లడీ స్కామ్. I was stunned even a bank is involved, bank people are involved in this. And the legal opinion which is given in the panel was a renowned advocate. Just because the papers are being given, they're given a legal opinion.
Yes.
Tell me what I need to do right now.
సార్ ఇప్పుడు వీళ్ళు ఈ డాక్యుమెంట్ రైటర్స్, ఈ బ్రోకర్స్ చేసే పనులు సార్ ఇవన్నీ. ఇప్పుడు డాక్యుమెంట్ రైటర్ కి ఇచ్చిన విలువ మన అడ్వకేట్ కూడా ఇస్తలేరు.
సార్ మాకు ఒక విషయం చెప్పాలంటే document writers are not professional people. Sorry to say this. They know the gist of the case, they know how to draft the case, but technicalities miss అవుతున్నాయి సార్.
నిజమే సార్, ఏం రాని వాడు బ్రోకరేజ్ చేసి ఆటో ఆఫీసులు కానీ
అలాంటి తప్పులు చేయడం మూలానే ఇప్పుడు నేను చెప్పిన జీపీఏ, ఏజీపీఏ హోల్డర్స్ ఏదైతే మాట్లాడుతున్నారో, ఎవడు ఇంకో పెద్ద ట్విస్ట్ ఏంటంటే ఈ కేసులో ఏజీపీ హోల్డర్ ఇస్ నో మోర్, జీపీఏ హోల్డర్ ఇస్ నో మోర్. వాడు చచ్చిపోయి 10 ఏళ్ళు అయిపోయింది. 10 ఏళ్ళు అయిన వాడికి జీపీఏ ఎక్కడ ఇచ్చారు సార్ వీళ్ళు?
డాక్యుమెంట్ రైటర్ సార్.
ఇందులో కలిసింది ఎస్ఆర్ఓ కలిసారా లేకపోతే డాక్యుమెంట్ రైటర్ కలిసారా ఇంకోటి కలిసారా తెలియదు సార్. పర్ఫెక్ట్ గా చెప్పాలంటే
వాళ్ళదే మాయ సార్. ఎస్ఆర్ వాస్ పొల్యూటెడ్ అయితేనే ఎటువంటి
సార్ మనం ఇప్పుడు కామెంట్ చేయలేం కదా సార్. ఇట్స్ ఓపెన్ బోర్డ్, మనం అలా కామెంట్ చేస్తాం.
ఇబ్బంది
ఎండ్ ఆఫ్ ది డే
సార్ అడ్వకేట్ గా పోతే మనకు విలువ లేదు, వాళ్ళకి ఇచ్చిన విలువ మనకి ఇవ్వట్లేదు. అది
సార్ వద్దు సార్, మనం వద్దు సార్, నెగిటివ్ కామెంట్స్ వద్దు. నేను ఒకటే చెప్తున్నాను, ఐఎమ్ టెల్లింగ్ ఇట్ వెరీ ఫ్రాంక్లీ. అడ్వకేట్స్ అనే వాళ్ళకి విలువ ఇవ్వండి. దయచేసి డాక్యుమెంట్ రైటర్ దగ్గరికి వెళ్ళొద్దు. డాక్యుమెంట్ రైటర్ దగ్గరికి వెళితే కొంతవరకే చేయగలుగుతున్నారు. ఐఎమ్ నాట్ ఫీలింగ్ నెగిటివ్ అబౌట్, వాళ్ళు ఇచ్చేవి కొంతవరకే ఇన్పుట్ ఇస్తున్నారు. అందరూ కూడా ఒకలాగానే చెయ్యట్లేదు. పాత మీరు అన్నట్టు పాత ఎవరైతే ప్రొఫెషనల్ గా వాళ్ళు వస్తున్నారో, తాతల ముత్తాతల నుంచి వాళ్ళు వస్తున్నారు, ఆ ప్రొఫెషన్ తీసుకుని వస్తున్నారు, వాళ్ళు బెటర్గా ఉన్నారు. కానీ కొత్త డాక్యుమెంట్ రైటర్స్ పుట్టుకొచ్చిన వాళ్ళందరూ కూడా ఎవరికి లేవు సార్, అంత స్కిల్ సెట్ లేదు. ఎవరున్నా సరే ప్లీజ్ అప్రోచ్ టు యువర్ ప్రాపర్ అడ్వకేట్ సో దట్ ఇట్ విల్ కమ్ టు ఏ కన్క్లూజన్ అండ్ నార్మల్ వే. వాడికి 10 రూపాయలు ఇద్దాం, వాడికి 10 రూపాయలు ఇస్తే పోతుందని ఇవ్వాలనుకుంటున్నారు. రేపు పొద్దున 10 రూపాయలు ఇచ్చే చోట మీరు ఒక 50 రూపాయలు ఇచ్చి 100 రూపాయలు ఇచ్చి వీటి దగ్గరికి అడ్వకేట్ దగ్గరికి ఎవరి దగ్గరికి వెళ్తే ఫ్యూచరిస్టిక్ గా ఆలోచించి దాన్ని ప్రాపర్ గా ఛానలైజ్ చేస్తున్నారు. ప్రజలకి చెప్పేది ఒకటే చెప్తున్నాను, అడ్వకేట్ ఉన్న వాడి దగ్గర ప్లీజ్ గో అట్, వాడి దగ్గరికి వచ్చి వాడికి కొంచెం డాక్యుమెంట్ చూపిస్తే ఏదో చూస్తాడు, మీకు ఒక సలహా ఇవ్వగలడు కదా. డాక్యుమెంట్ రైటర్ని లేదా బ్రోకర్ని పట్టుకుంటే మీకు ఏం వస్తుంది? Advocate anavadu is more valuable for the people who are really troubling. Don't believe the brokers or document writer. Please come to a conclusion and come to a proper advocate so that he will guide them. మీ పక్కనింటి వాళ్ళ దగ్గర ఉండి మీ వీధిలో ఉండి వాడికి ఒక్కసారి డాక్యుమెంట్ చూపించండి సార్. నేను ప్రజలు కోరుకున్నాను, ఎందుకంటే యూట్యూబ్ లో టెలికాస్ట్ అవుతున్నది కానీ ఐఎమ్ టెలింగ్ దట్.
సార్ వెన్ అడ్వకేట్ అప్రోచ్డ్ SROs మా అడ్వకేట్ వెళ్తే SROs సో మెనీ షోయింగ్ ది లిటిగేషన్స్, ఈ డాక్యుమెంట్ ఇది లేదు, అది లేదు, ఇది లేదు. అదే ఇప్పుడు మీరు అన్నట్లు బ్రోకర్ డాక్యుమెంట్ రైటర్ వాడు చదువుకోలేకుండా కూడా వెళ్తే ఆ డాక్యుమెంట్ ఏం చూడాడు సార్, ఓకే ఆ ప్రాపర్టీ ఉందా, ఓకే బౌండరీస్ ఉన్నాయా, ఓకే రైట్, ఓకే అంతే సంతకం చేసి. అవును సార్, మీరు ఇప్పుడు అది రిజిస్ట్రేషన్ టైం మాట్లాడుతున్నది, రిజిస్ట్రేషన్ టైం. బట్ ఇక్కడ ఏమవుతుందో ముందు రిజిస్ట్రేషన్ జరిగేక ముందు ప్లీజ్ వెరిఫై ద డాక్యుమెంట్స్ ప్రాపర్లీ బై షోయింగ్ ద డాక్యుమెంట్ టు ద ప్రాపర్ అడ్వకేట్. పబ్లిక్ అవేర్నెస్,
అది అవేర్నెస్ మనం క్రియేట్ చేయాలి కదా సార్. We got 5 minutes more to wind up the show. So we will continue the debate again tomorrow again. Sir, చెప్పండి.
Sir, this is Nikhil sir.
చెప్పండి నిఖిల్.
సక్సెషన్ సర్టిఫికేట్ ఒబ్టైన్ చేసుకున్న తర్వాత ఆ ల్యాండ్ రిజిస్ట్రేషన్ చేసుకోవడం నెసరీయా సార్?
ఖచ్చితంగా చేసుకోలేదు. సక్సెషన్ ఎందుకు తీసుకున్నారు మరి మీరు?
అంటే అది సేల్ చేద్దాం అనుకుంటున్నారు కదా.
సేల్ చెయ్యాలనుకున్నా సరే, ఏం చెయ్యాలనుకున్నా సరే, సక్సెషన్ మీ ఈ కోర్ట్ డిగ్రీ ఏదైతే మీ దగ్గర ఉంటుందో ఆర్ అన్ ఆర్డర్ కాపీ పెట్టి మీరు రిజిస్ట్రేషన్ చేయించుకోవచ్చు. కానీ ఈజ్ ద పర్సన్ ఈజ్ అలైవ్ ఆర్ నాట్, ఫస్ట్ ఆఫ్ ఆల్ అది.
No, his father is not alive.
Then how do you come to registration? Family certificate అయిందా లేకపోతే లీగల్ ఐర్ తీసుకున్నారా?
గవర్నమెంట్ ఎంప్లాయీ కాబట్టి ఫ్యామిలీ మెంబర్ సర్టిఫికేట్ ఇచ్చారు. సో
ఫ్యామిలీ మెంబర్ సర్టిఫికేట్ తీసుకున్న వాళ్ళందరిలో ప్రతి ఒక్కరు సంతకం పెట్టాల్సి వస్తుంది. రిజిస్ట్రేషన్ ఆర్ దే రెడీ?
They are ready sir.
Then you can go ahead.
ఫ్యామిలీ సెటిల్మెంట్ డేట్ సార్,
ఫ్యామిలీ సర్టిఫికేట్ ఫ్యామిలీ సెటిల్మెంట్ డీడ్ ఒకటి రాసుకుని you can go ahead with the registrations.
Yes, yes sir.
Only thing is that మళ్ళీ చెప్తున్నాను, ఫ్యామిలీ సర్టిఫికేట్ లో ఉన్న మెంబర్స్ మాత్రమే చేయగలరు. No other fellow can do it. No other fellow can come and do this.
And sir, ఇది SRO ఆఫీస్ కి వెళ్తే ఆయన ఏమన్నా అంటే లీగల్ ఎయిర్ సర్టిఫికేట్ తీసుకోమని.
నాట్ రిక్వైర్డ్. నాట్ ఈజ్ గవర్నమెంట్ ఎంప్లాయీ. మీరు షో చేయడానికి మీరు ఆల్రెడీ కోర్ట్ నుంచి ఆర్డర్ తెచ్చుకున్నారు కదా, యూ హ్యావ్ ఎ పెన్షన్ ప్రూఫ్ ఉంటుంది కదా, ఈయన ఈ సో కాల్డ్ గవర్నమెంట్ ఎంప్లాయీ ప్రూఫ్స్ ఉంటాయి కదా.
సార్
ఏమీ కాదు. ఓన్లీ థింగ్ ఇస్ దట్ మీరు మాట్లాడాలి. రిజిస్ట్రేషన్కి వెళ్ళి మీరు మాట్లాడితేనే పనులు అవుతాయి కొన్ని. You have to speak, open up your mouth and you speak in SRO saying that he is a government employee, I have a family certificate, these are the things who are available, these are ready with me, సక్సెషన్ యాక్ట్ తెచ్చుకుని ఇన్ని చేసుకున్నాం, అన్ని డాక్యుమెంట్స్ చూపించండి, జరుగుతుంది.
సార్ తెలంగాణలో సార్ క్వశ్చన్ సార్
3 minutes 38 seconds అందరూ చెప్తే మీకు కంప్లీట్ అవుతుంది.
సార్ తెలంగాణలో
సక్సెషన్ యాక్ట్ ఎంత టైం పడుతుంది సార్?
ఎవరు మాట్లాడుతున్నారు?
సార్
నిఖిల్, I'll call you back and I'll explain you. I have your number.
Okay
sir. K.Santhanam గారు చెప్తున్నారు సార్.
సార్ తెలంగాణలో ఏదైతే గవర్నమెంట్ ఎంప్లాయీస్ ఉన్నారో వాళ్ళు రెవెన్యూ డిపార్ట్మెంట్ లో లీగల్ సర్టిఫికేట్ ఇస్తున్నారు, ఎంప్లాయీస్ కి ఇస్తున్నారు
సార్. లీగల్ సర్టిఫికేట్ ఇస్తున్నారు కానీ కొన్ని విషయాల్లో ఇక్కడ తెలుసుకోవాల్సింది ఏంటంటే ఇప్పుడు రామచంద్రమూర్తి గారు శ్రీరామచంద్రమూర్తి గారు చెప్పినట్టుగా ఎలా ఉందంటే ఇప్పుడు ప్రతిదీ కోర్ట్ ఆర్డర్ కింద అదేదో స్పెషల్ మేజిస్ట్రేట్ అని ఒక ముద్ర వచ్చి పెడుతున్నారు, కానీ అది బేసిక్ గా లేదు. మా దగ్గర డాక్యుమెంట్స్ స్పెషల్ మేజిస్ట్రేట్ అని స్టాంప్ వేసి ఇస్తున్నారు, కానీ అది బ్యాంక్ వాళ్ళు కానీ మిగతా ప్రాస్పెక్ట్స్ కానీ దోస్ పీపుల్ ఆర్ నాట్ యాక్సెప్టింగ్ ఎట్ ఆల్.
అది ఇప్పుడు ఇవ్వట్లేదు సార్, సెకండ్ క్లాస్ మినిస్టర్స్ వాళ్ళు
ఇవ్వట్లేదు, తీసుకునేది యాక్సెప్ట్ అవ్వట్లేదు సార్.
ఓకే సార్,
నథింగ్ ఈస్ హ్యాపెనింగ్.
అందుగురించి రెవెన్యూ డిపార్ట్మెంట్ వాళ్ళు ఏం చేస్తున్నారు సార్, ఇప్పుడు బ్యాంకులో అమౌంట్ ఉంటే గానీ ఈ ఫ్యామిలీ మెంబర్స్ ది వాళ్ళు బ్యాంక్ వాళ్ళకు ప్రొఫార్మా ఇస్తున్నారు సార్.
అవును,
తీసుకొని రెవెన్యూ డిపార్ట్మెంట్ కి వెళ్తే వాళ్ళు లీగల్ సర్టిఫికేట్ అప్పుడు ఇస్తున్నారు.
అవునవును, దట్ ఈస్ వాట్. ఇప్పుడు వాళ్ళు ఇచ్చినా సరే అది యాక్సెప్ట్ అవ్వట్లేదు సార్. బ్యాంక్స్ దే ఆర్ నాట్ టేకింగ్ ఇట్. బ్యాంక్స్ కానీ గవర్నమెంట్ అఫీషియల్స్ కానీ ఎస్ఆర్ఓ కానీ తీసుకోవట్లేదు. Obtain a proper family certificate if he is a government employee, or else if he is a private employee, obtain a legal heir certificate.
Okay, sir.
This is my sincere advice, so that you can go ahead with the registrations or property litigations which is happening within the family.
Sir, I want to know, sir, one doubt, sir.
Sir, 1 minute, what, sir? Suryanam, na number తీసుకోరా sir, please, I'll call you back.
Okay, thank you.
Please give me a call on my number, I'll clear it. 891-964-0157 is my number.
I got it.
Okay.
Please give me a call, I'll talk to you. You can end in 1 minute 30 seconds. Any doubts? I'm clearing up today.
Okay, sir.
Sir, మీరు నాకు ఫోన్ చేయండి, I'll talk to you right now.
Sure.
Thank you very much. Thanks to one and all for the beautiful support, and I hope a very good discussion.
Thank you, sir. Thank you.
Sir?
సంతానం గారు దొరకడం మీ అదృష్టం
సార్. ఆయనతో 15 ఏళ్ళ నుంచి వేగుతున్నా సార్. 15 ఏళ్ళ నుంచి వేగుతున్నా నేను. వాళ్ళ కొడుకుని ఆయన ఏమంటారు, అడాప్టెడ్ సన్ ఏదో అంటాడు, బీజాక్షరాలు రాసి పంపిస్తున్నాడు. నా సిస్టర్ అక్కడ కూర్చుంది, అలా వీడియోలో చూస్తున్నది. అమ్మాయి సిస్టర్, అమ్మాయి పేరు వరలక్ష్మి. ఇద్దరికి కలిపి నూరుతున్నాడు ఈయన. నూరాడు కాబట్టి ఇలా ఉన్నా స్వామి. సార్, కెన్ ఐ హ్యావ్ యువర్ నెంబర్ చక్రవర్తి గారు? ప్లీజ్ చాట్ బాక్స్ లో వేసేయండి సార్, మీ నెంబర్ నేను ఫోన్ చేస్తాను.
ఓకే, థ్యాంక్ యూ.
రైట్ సార్, థ్యాంక్ యూ వెరీ మచ్.
థ్యాంక్ యూ.
వైల్డ్